Mic check. Good morning, everybody, and welcome to the 2021 Dickinson Laws Employment Law Seminar. I am Jill Jensen Welch, and I will be your MC for today, as well as one of the presenters and co-presenters throughout the day. You know, today we want to help you get back in the groove since the pandemic. And, you know, there probably are some things that you neglected because of the pandemic that, out of necessity, you now need to get back to. And we're going to try to help you do that. There may be some things that you've missed during the pandemic that we want to help you get back up to speed on. And of course, there are still pandemic issues requiring your attention. So don't worry, we're here to get you up to speed in record time with all the information we've compiled for you. And we have some great sessions today, including the following, and I'm just going to run through them really quickly. So we're going to start out with me talking about the National Labor Relations Board and your policies. Then we're going to have a little case law update from the Iowa Supreme Court and U.S. Supreme Court. Then we're going to have a wonderful outside speaker talk to us about DE&I plans. Then you will hear from a couple of our attorneys about pregnancy and breastfeeding and maternity leave. After lunch, you will hear Brian and I talk about restrictive covenants, non-competes, non-solicits. Following that will be David Gonzalez talking to you about immigration updates. After a short break, we will get into a documentation session where we'll roll through kind of a scenario that will take very different twists and turns on documentation. Mike Stabell will come in then and give you an update on what's happening at the Wage and Hour Division since Joe Biden took office. And then we will talk about remote work and how that has changed since the pandemic and what pandemic changes may be long-lasting. And finally, we will end with the topic on all of your minds, no doubt, and that is mandatory vaccination laws. Now, I do want to let you know, if you haven't figured this out yet this morning since you've woken up, that OSHA just issued its emergency temporary standard for employers with 100 or more employees, and the Centers for Medicare and Medicaid issued its new regulations this morning. Altogether, this is double-sided. They are approximately 800 pages to be read. So we will not be able to give you a complete update on all of this today. We do have Sierra McConnell, one of our new associates, who's going to be attempting to figure out as much as she can about the OSHA ETS, and we will talk about that at the end of the day. We will also talk about Iowa's new vaccine waiver law at the end of the day as well. So it's a fun-filled, packed day full of information. Those of you who need continuing legal credits, we are pre-approved for 5 credits. Those of you who have HRCI or SHRM certifications, we are not pre-approved for those, but you can submit materials or agenda and get approval for today's session as well. I want to cover just a couple of housekeeping items for you before we get started. So we are going to try to start all of the sessions at designated times. And you were sent an agenda along with a link for the materials and how to connect with us today via emails yesterday and this morning. So that's where you'll be able to find out the designated times, all right? We will have short breaks in the morning, one in the morning, one in the afternoon, and of course, an hour for lunch. If you have any questions during the session and want to submit them, you need to email them to our Crackerjack paralegal, Tiffany Rusa, and her email address is trusa, R-O-O-S-A, @dickinsonlaw.com, okay? Next, materials are available at the link that you were given, as well as at dickinsonlaw.com/backinthegroove. Our session today is being recorded and will be available on YouTube after the session. It will use the same link that you used today to link in, so that's nice and convenient for you. It will also be available at a hyperlink on our website. We also have a secret word game today that we're playing, similar to what we did last year. So every one of our 10 presentations will have one secret word in it, and one of our presentations will have 2. Not telling you which one yet. Along with your email that gave you the hyperlink to get into today's session and to get your materials, you should have received information about the secret word game. And you should have received a hyperlink to this form. And you just fill out the secret words, and then you will send it to us via email to marketing@dickinsonlaw.com after the end of the session. We will be having some drawings for prizes, which will include a phone soap, something that gets your phone all cleaned up so you don't have all those germs all over it. Good thing for a pandemic, right? And doxies to help you keep your devices all charged up. And we also have gift cards from Target, Casey's, and Starbucks that we will be giving away. Winners will be chosen at random. Also, at the end of the session today, you will receive an email with a survey to fill out to give us feedback on how we did. We love that feedback. We want to hear both the good, the bad, and the ugly. It really helps us make the seminar better year to year. If you complete that survey, you can email us also at marketing@dickinsonlaw.com to let us know you've done it, and we will have more drawings for you for the same wonderful prizes. So if you don't win a prize in the secret word game, you can win a prize if you fill out our survey at the end of today. All right, I think I have covered all of the housekeeping, and without further ado, let's get started. And guess who's first up? It's me. So, and this session is called the Two-Song Playlist, the National Labor Relations Board, and your policies. Now, how would you like to have only 2 songs on your playlist? Pretty boring, right? But when it comes to the NLRB, they have kind of a 2-song playlist, and it's kind of exciting, quite frankly. Every time the presidential administration changes, the NLRB changes. Who's in power changes on the makeup of the board, and also in the very powerful general counsel position. And since President Biden took office on January 21st of this year, there have been a lot of changes at the National Labor Relations Board. And we're going to talk about those and how they may impact your policies. All right, so our first slide talks about why you should care about the National Labor Relations Act. This applies only to private sector employers. So I have to tell you, I'm sad to say, that if you are a school, a public school employer, if you are a municipality, if you are a state or local government entity, you can probably not pay a whole lot of attention to me for the next few minutes. Certainly what I'm saying may give you some ideas about your own issues with labor relations, but really this message is for the private sector employers. So the National Labor Relations Act, Section 7, covers all private sector employers, not just those who actually have unions or are in union organizing drives. And many of you have seen and heard this from us before, as well as other places before. It used to be when I was in human resources an age ago with the dinosaurs, we didn't really worry much about the National Labor Relations Board. But probably about 10, 15 years ago, we started really worrying about what they were doing. They started infiltrating more and more what non-unionized private sector employers were doing. And they focused on this Section 7 that provides all employees with the right to engage in concerted activities for the purpose of not just collective bargaining, but also other mutual aid and protection. Because if employees can't talk to each other and complain about problems in the workplace, then they're not going to be able to get together and form a union. So we have to protect those pre-unionized activities as well. All right. So what we want to talk about next is general counsel memos, and this is the focus of this presentation today. And we have to talk a little bit about who general counsel is. So in the National Labor Relations Board, there is a board that listens to and hears cases and makes decisions about whether the National Labor Relations Act has been violated or not. But before they get there, and when they're there, they are prosecuted by the Office of the General Counsel. That is the top legal person at the National Labor Relations Board. And the General Counsel sets the tone for what the administration and what the National Labor Relations Board is going to key in on, what they're going to care about, what will take priority for the organization under a particular administration. Now, under President Trump, we had General Counsel Peter Robb, and he refused to resign when President Biden took office, because he had a few months left on his term. President Biden asked for his resignation, he refused it, and so he was fired. And this is, as far as we know, the first time in history that a new incoming president has fired the general counsel of the National Labor Relations Board. So Peter Sung Orr is an attorney in the National Labor Relations Board, Office of the General Counsel, and he was named as acting general counsel. And after that, in July of this year, Jennifer Abruzzo was named the actual general counsel. She was appointed by the president, and the Senate affirmed her by the narrowest of margins. In fact, Vice President Kamala Harris had to come in and break the tie. So Jennifer Abruzzo was approved for her position by a 51-50 vote. She had 23 years of experience at the NLRB, had recently left it in December of 2017 to work for a union. So she definitely has a union perspective. And the next slide is your first secret word of the day. And this is, believe it or not, me when I weighed, very much less than I do now. This is a picture of me from the fall of 1978 when I was the majorette of the Manila High School marching band. So your first secret word is majorette. All right, moving back to some content here. We want to talk about the acting general counsel Orr's first general counsel memo of import, and that was issued just February 2nd of 2021. And what this did is it set forth a list of cases that the National Labor Relations Board had recently decided that are targeted to be overturned and to be have different outcomes in future cases. So included among them was the handbook rules that had previously been issued by General Counsel Peter Robb as a result of the Boeing decision. Now, some of you may remember back in 2019 when we last were able to get together in person that Russ Sampson and I did a session on this, and we talked about the 3 categories for policies under the Boeing decision and under General Counsel Robb's memo. And the first category was policies in your handbook that are definitely okay, and language and sentences that are definitely approved and they do not violate the employee's rights to engage in concerted activities. The second category were policies that were sort of on the edge, had to look deeper, look at some factors to determine whether or not they were okay. And then the third category was policies that were definitely not okay, sentences and policies. You could not have these things because they would be considered per se violations of the law. Well, one of the things that acting general counsel Orr did is he threw out that memo from General Counsel Robb. Now, Boeing is still a decision that's out there. We still have the 3 categories for policies. We still know what the factors are to decide whether you're in which category. But what's been thrown out is actual policies and actual language that is okay or put into each one of the sections. So we are in a state of flux. Do not know for sure at this time what direction the NLRB will go, but we're pretty assured it's going to be different from what those policies were categorized as before. The next thing that acting general counsel Orr did was at the end of March of 2021, he put out another general counsel memo that focused it on health and safety issues in the workplace that was triggered because of the pandemic. And one of the things he wanted to talk about here was that there are fundamental precursor actions before unions are organized that are protected by the National Labor Relations Act. And he gave some examples of those. And these are things that tied to not only the pandemic, but also social justice matters that occurred during the pandemic. And he gave some examples of things that he felt National Labor Relations Act. So let me give you some examples here. So there was a hotel employee who did an interview with a journalist about minimum wage. And they talked about how earning just the minimum wage was affecting this employee and how it was affecting her coworkers, and how legislation that might increase the minimum wage to $15 an hour would really impact her and her coworkers. This is one of the things that acting general counsel Orr said is a precursor activity that he felt would be protected by the National Labor Relations Act. So this just gives you a flavor for the things that, social issues, political issues that your employees may be involved in outside of the workplace could be considered protected activity. So the message here is you need to be really careful how and what you are disciplining employees for. Unfair labor practice charges can be filed if employees feel like their rights have been trampled on under the NLRA. In fact, our firm has seen an uptick in unfair labor practice charges. I actually handled my first one this year, and our firm has seen about 6 to 7 of those charges in 2021, which is a significant increase over what we have seen in previous years. All right, let's move on to Jennifer Abruzzo. She came into play here in late July, and by August 2nd of 2021, she puts out her first general counsel memo. And this is a memo to all the regional directors around the NLRB telling them, here are the things I want to key in on. And she categorized that in 3 categories. And the first category is, these are decisions that we want to have reconsidered. She felt that they overruled precedent. By precedent, she means precedent from the Obama administration largely, and that they've been overruled by Trump administration decisions. So she had a list of 11 things that she wanted to look at. I'm not going to cover all of them, but I want to call your attention to, first of all, number 1, which is handbook policies. That was the number 1 thing on Jennifer Abruzzo's list that should be a priority for regional directors to look at. And she listed the policies that are of particular interest to her. First of all, confidentiality policies. Second of all, non-disparagement policies. Third, social media policies. We all know that has been a mess for years, and it's going to continue to be a mess. Media communications, civility, respect, and professionalism policies, offensive language policies, and camera and recording device policies in the workplace. She also is specifically targeting confidentiality provisions in things like severance agreements, separation agreements, employment agreements, and restrictive covenants as well. So we need to be on the lookout that we may have to change our template agreements or the types of agreements we have with employees in order to comply with what the National Labor Relations Board may be doing in the future. Settlement agreements she also targeted, and we're going to talk about that in a second, as well as the employee independent contractor distinction. And that has long been, for many years now, an issue both at the Department of Labor as well as the NLRB, and it's going to continue to be an issue. All right, the next General Counsel memo that Jennifer Abruzzo put out we're going to skip to the 981, and this one was about seeking full remedies. So what the General Counsel is doing here is she is encouraging the National Labor Relations Board, when they are issuing decisions and awards to employees, to explore broader remedies than they have provided in the past. She believes that the National Labor Relations Act allows for this. So she is encouraging the board to do things like award consequential damages. And examples of those kinds of things are, if your employee loses their health care because they lost their job for an unlawful reason under the National Labor Relations Act, that the employer should be required to pay for new health care or out-of-the-pocket healthcare expenses. What if your home was foreclosed on or your car was repossessed? That is a consequential damage of you losing your job, and Jennifer Abruzzo wants the board to provide for damages for employees for those kinds of things. If you were an undocumented worker, or you were a documented worker but you were getting a visa that your employer sponsored and losing your employment lost your sponsorship for that, expenses related to that are also recoverable. So you can see the list there of things that she's looking for the board to do. In addition, when there is an adverse decision against an employer, a notice is usually posted in, physically, in paper, in break rooms and places for like 60 days. And she wants these to be digitally posted as well, which will, provide broader access to these notices, and probably they'll have to be posted over and over again in order to renew them. Ms. Abruzzo also put out another General Counsel memo on the 15th of September, and this one was about settlement agreements. So if you do happen to violate the National Relations Act, or your employee thinks you did, and they file an unfair labor practice charge, you may not want to go all the way to a hearing before the board, which is like a trial in court. And instead, you may want to settle that. You may decide it's costing too much money, you want to settle and move forward. Well, settlements are going to be very difficult under this new direction from Jennifer Abruzzo. She is telling her regional directors that, listen, you have even more flexibility in what you put in your settlement agreements than the board has in what they give out for awards in their judgments in cases. So she has set forth some of the things that she wants the regional directors to do. First of all, she is focusing on reinstatement as the most important remedy, that she wants that in virtually every case where she can get it. She says that this is the very public manner of demonstrating the enforcement powers of the National Labor Relations Board. It informs other employees of their legal rights, and that if they get terminated, they can come back into the workplace. She also wants 100% of all back wages and benefits owed to the employee. I think she does not understand the meaning of the word compromise in a settlement. She wants everything that she could get if they went forward and actually won before the National Labor Relations Board, including these consequential damages that I talked about in the previous slides. She also wants any rule that is unlawful to be rescinded at the employer's workplace, as well as any rule that looks lawful on its face, but that the employer interpreted or applied in an unlawful manner. She wants the rule thrown out altogether. So throwing out the baby along with the bathwater. It's not good enough for the employer to just fix their application of the rule. They have to also throw out the rule altogether. The other big thing, I think, is that if the employer defaults on any provision in the settlement agreement, they agree in the settlement agreement that they will take a judgment against them, and that they will just have to pay a bunch of damages, that the complaint will be reinstated, and it will move forward as if they have admitted to liability. The next slide talks again about some of these additional remedies. So what are the takeaways for you from this? Number one, at minimum, I think your handbooks and certain policies in them need to be reviewed probably 1 to 2 years after there's any change in the political party in the presidential, in the White House. That is the time where you should contact your employment law attorney and say, hey, has enough happened in this change of administration for a review of our handbooks? And put that on your calendars. You certainly might want to review your handbooks more frequently than that, but that would be, I think, the bare minimum. Second, get advice from competent employment and labor law counsel before you discipline an employee for virtually anything, including conduct that they engage in outside of the workforce, because it's going to be a much broader scope on what is protected under the National Labor Relations Act than I think we've ever seen before. Third, prepare for these unfair labor practice charges. Try to make sure that your policies and your practices are in line with it so you can avoid them, because settlement of them will be very difficult. You're going to have to gird your loins if you end up getting into one of these unfair labor practice charges and you need to face settlement of it. And of course, as always, pay attention to what's happening at the National Labor Relations Board. Even if you don't have a union in your workplace, it still matters, so pay attention. Thank you so much for your time and attention, and I am going to introduce our next speaker. I think we have just maybe 30 seconds to go. Sierra, are you all ready to go? All right, very good. So I want to introduce you to Sierra McConnell. Sierra is our newest attorney in our labor and employment section, and as one of the newest attorneys at our firm, she of course is doing a lot of everything, but she has a particular interest in employment and labor law, and we are snatching her up right away. So Sierra is going to give you a case law update of what has happened at the U.S. Supreme Court and the Iowa Supreme Court this last year for decisions that impact you as employers. And Sierra and the Supremes, take it away. I didn't know we had an intermission.
last year. In the first half of this year, several cases were decided by the United States Supreme Court that may have significant impact in the employment and labor law section. The Iowa Supreme Court also decided some big cases that may impact your business moving forward, including in drug testing, fair chance laws, and disability discrimination. I've highlighted a few cases on this slide here, but we won't have time to go in detail of each one of them. So if you guys have questions, please refer to those presentation materials that we have handed out to you, and then reach out if you have any questions on something we end up not covering. Let's start with the Iowa Supreme Court cases. One of the topics that the Iowa Supreme Court covered this year was disability discrimination. And this case, Rumsey versus Wood Grain Millwork, is a dense case. It taught employers a lot this year. And we'll go through most of it, but not all of these lessons. In this case, includes the not uncommon, yet often murky intersection between workers' compensation and disability discrimination. The particular employee in this case, Rumsey, had been deaf since birth. He could hear loud noises, but he primarily relied on a sign language interpreter and reading lips to communicate. Rumsey started his job in 2007 and had been described as being an exemplary employee, and he had even earned Employee of the Month twice with his time there. In early 2015, Rumsey was working on a heavy-duty job, and he was lifting large window panes from a rack to a work table. And during this time, he ended up injuring his back and his shoulder. So for the next several months, Rumsey went and saw doctors, and they gave him various work restrictions. And the employer complied with these restrictions by assigning him to light-duty work. Eventually, the doctors issued Rumsey a permanent 10-pound lifting restriction. The human resource director worked with Rumsey to implement these work restrictions imposed by his doctors. However, Rumsey continued to report shoulder and back pain, despite the doctors determining he had reached maximum medical improvement. Eventually, Rumsey requested a sit-down restriction and then went home for the remaining part of the day. The HR director was confused at this point because in this point of his doctor visits, he was only being treated for his shoulder pain. So the sit-down restriction just didn't make sense to her. So she ended up calling the doctor and asking for more of an explanation. The doctor ended up retracting that sit-down authorization. So when Rumsey returned to work the next day, there was no sit-down restriction for him in his modified accommodations. Rumsey got upset and asked to speak to both the HR director and the production manager. Rumsey requested a sign language interpreter to be present and wanted to talk to his workers' compensation attorney. Now, as Rumsey recalls, the HR director and the production manager stopped him from talking to his attorney and refused to allow him to have a sign language interpreter. However, the HR director and the production manager recall Rumsey yelling and using profanity, knocking the doctor's papers out of the director's hands, and behaving in such a threatening manner that the HR director ended up in fear of Rumsey. After this meeting, Rumsey was fired. Rumsey then brought claims for disability discrimination, failure to provide reasonable accommodations for both his sit-down restriction and his request for that sign language interpreter. He also brought claims for retaliation. Now, under the Iowa Civil Rights Act, for an employer to act in disability discrimination, the employee must show that he has a disability, he is qualified to perform the essential functions of a job, and the circumstances of his termination rise to an inference of illegal discrimination. For a failure to provide a reasonable accommodation, though, the employee must prove that the employee was a qualified individual, the employer knew of this disability, and the employee requested a reasonable accommodation employee suffered an adverse employment action. So the element at issue in both of these claims, and really the focus of the case, was whether Rumsey was a qualified individual that could perform the essential functions of a job. So focusing first on Rumsey's claim for a sit-down restriction, the parties agreed that Rumsey's prior job of lifting those large window panes wasn't reasonable anymore because of his work injuries. But that's not the end of the inquiry, because Rumsey could show that he was a qualified individual for any job currently available with the employer. However, an employer is not required to create a job for an employee in order to accommodate him. But if Rumsey could show he could have been reassigned, then he could show he was a qualified individual. But reassignment requires a current one, and the only position that Rumsey was claiming that he could perform was a beating job, and this is what he used throughout trial. The problem with this beating job for the employer was that it was not a permanent, regular job. It was a light-duty, temporary position created to give him suitable work while he was recuperating from his workplace injuries. Again, because an employer does not have to create a job or even take tasks from other employees to give to the employee in order to accommodate, Rumsey's claim for his disability discrimination and failure to accommodate for the sit-down restriction had to fail. The Iowa Supreme Court also concluded that Rumsey failed to present evidence to support his retaliation claims for that sit-down restriction. To have a case for retaliation under the Iowa Civil Rights Act, the plaintiff must establish he was engaged in statutorily protected activity, he was subjected to an adverse employment action, and he must show that a causal connection between his participation in that protected activity and the adverse employment action. Although the Iowa Supreme Court has not directly addressed whether requesting an accommodation is a protected activity, even assuming it was or is, a request for an accommodation that clearly would not enable an employee to perform the essential functions of any currently available job would not be reasonable and therefore not appropriate. So there would be no basis for finding the employee was engaging in a protected activity. Therefore, Rumsey's retaliation claims for the sit-down restriction failed. But now let's discuss Rumsey's claims for disability discrimination, the failure to accommodate, and retaliation regarding his request for a sign language interpreter. As mentioned already, the employee failed to establish he could perform essential functions of a job. So therefore, a claim for disability discrimination on his hearing impairment, as well as his work injury, fails. But for the failure to accommodate and the retaliation claims, the Iowa Supreme Court could not determine whether the jury gave Rumsey a favorable verdict due to his sit-down restriction or for that sign language interpreter request. So the Iowa Supreme Court remanded the decision. So on remand, the employer will have to prove it would have made the same decision even if they had not taken into account the request for a sign language interpreter. This is because Iowa law has concluded that an employee who engages in terminal conduct cannot avoid these consequences of his actions by then requesting an accommodation for those actions. The fighting issue on the retaliation claim is whether the employee established a causal connection between his participation in the protected activity, here requesting an interpreter, and the adverse action, or here Rumsey getting fired. So like I said, this case is jam-packed with good information for employers, as it even dives into whether a person can be personally liable for disability discrimination claims. I'm not going to go into detail on this claim, but you should be aware that the Supreme Court did determine that if an individual has the ability to effectuate an adverse employment action, they may be subject to individual liability. This may signal a narrowing of the individual liability under the Iowa Civil Rights Act, and this may have consequences in the future for harassment claims. But that's a case for another day. Another topic that the Iowa Supreme Court covered was ban-the-box ordinances. What has now evolved into fair chance laws, the ban-the-box ordinance from Waterloo brought attention to this Iowa town. So what is ban-the-box? Historically, ban-the-box and similar criminal history laws were intended to prohibit employers from asking about criminal history on job applications. However, as criminal history laws have evolved and developed in recent years, now it is not only to prohibit inquiries into criminal history on those applications, but to also dictate the procedures that must be followed as an employer can determine whether or not to hire the employee at all. Hence why they're now called fair chance laws. So on November 4th, 2019, the City of Waterloo voted to enact Ordinance 5522. This ordinance regulates the time when an employer can inquire into a prospective employee's criminal history and also regulates whether an employee can consider the employee's criminal history at all while making a hiring decision. First, the ordinance prohibits all employers in Waterloo from asking about criminal history on a job application. Hence, it's a ban-the-box law. But it also bars employers with 15 or more employees from making any inquiry into an applicant's criminal history until a conditional offer of employment has been made. And it also prohibits employers of 15 or more employees from making an adverse hiring decision based solely on arrests or pending criminal charges. Hence, it's a fair chance law too. The Iowa Association of Business and Industry, or Iowa's ABI, claimed the ordinance violated Iowa Code Section 364.3, subsection 12A, which limits the abilities of cities to regulate employment terms and conditions. This code section preempts ordinances that prescribe different terms and conditions of employment. This includes, most notably, local minimum wage ordinances, which were the flashpoint of debate back in 2017. Yet, to the extent that Ordinance 5522 here merely delays an inquiry into criminal history means it is not prescribing different terms or conditions of employment. Therefore, the Iowa Supreme Court held that the first regulation under the ordinance that controls when an employer can inquire into criminal history does not provide for terms and conditions of employment. It simply addresses the timing of the criminal history inquiry. This is allowed under state law and therefore upheld in the ordinance. However, the second regulation that does not allow certain employers to turn down or not hire an employee with certain types of criminal history actually sets the terms and conditions of employment. And this is not allowed under state law and therefore was invalid under the ordinance. So what is the result from this? The Iowa Supreme Court basically just deleted the parts that were invalid and left with just the timing regulation of it. So given the growing number of ban-the-box ordinances around the country, and now that it has been upheld in Iowa, a wise employer will remove questions about criminal history from employment applications. Instead, you should be asking these questions on a separate form given to the candidate when a conditional offer of employment has been made. The Iowa Supreme Court also decided cases regarding private sector drug testing, and they decided 2 cases on this issue, actually. We covered these cases last year when they were at the Iowa Court of Appeals, and now they have made it through the Supreme Court. I'm not going to dive into these cases either, but let's still see what they taught us. So the drug testing lessons, what did we learn from these cases? Iowa's private sector drug testing law is detailed. It has lots of traps that employers can easily fall into. Drug testing policies should be very clear, detailed, and comply with Iowa law. And although under these cases, the standard is substantial compliance for these laws, full compliance with each part of the law is the best way to avoid litigation. Now let's discuss cases from the United States Supreme Court. And here is your hidden word. So this is your second hidden word, and it's violin. And I chose violin because I was first chair of violin from 6th grade all the way through high school. So that's a fun fact for you. So go ahead and write this down on your worksheet provided to you and submit it, and you could win some fun prizes. So the United States Supreme Court decided many issues, but one of them was the employee trespass into computer files. And the case of Van Buren helps answer an important question for employers about the strength of the Computer Fraud and Abuse Act, which is a federal statute that imposes both civil and criminal liability for unauthorized access of computers. Broadly speaking, the Act allows employers to sue employees who trespass into computer file folders and servers in order to copy or transfer confidential information and trade secrets. So here's what happened to bring this case to the court. A police officer was authorized to search computer records about license plates for law enforcement purposes. However, he was also searching the records and obtaining information for improper private purposes. The FBI targeted the officer through an informant and offered the officer thousands of dollars for license plate related information. The officer then accessed this information for non-law enforcement purposes, was arrested, and charged with 2 counts of fraud, including 1 count of Computer Fraud and Abuse Act. Van Buren raised a critical question about what happens when an individual is authorized to obtain some information, but goes beyond the authorization for other purposes. The United States Supreme Court held that an individual exceeds authorized authority under the Computer Fraud and Abuse Act when he accesses a computer with authorization, but then obtains information located in particular areas of the computer, such as file folders or databases, that are off limits to him. This means the officer's actions were not covered under the Computer Fraud and Abuse Act because he had authorization to obtain that information, even if he was using it for non-law enforcement purposes. Interestingly, the court noted that a broad interpretation of the statute would criminalize a breathtaking amount of commonplace computer activities, such as sending a personal email or browsing the news for the day. The court now, from this case, has significantly narrowed the applicability of the Computer Fraud and Abuse Act to employment cases. Brian and Jill will touch on this later today in the session about restrictive covenants. This decision suggests that employers should review employee computer handbooks to make sure their policies are defined more narrowly and so that they know exactly what an employee is authorized to do. In that way, they can protect all of their sensitive data. The United States Supreme Court also decided on the topic of unambiguous arbitration clauses. This was a case that had an unambiguous arbitration clause, but yet it was forced not to sit in arbitration. I won't go into detail on this one either, but you should be clear to review these policies so you know exactly what you're getting into in case you need to use arbitration. The United States Supreme Court also decided a case on labor organizing on ag employers' grounds. The lesson from this case is that agricultural employers' land is still personal property and therefore may provide more protections for the employer than other employers, as the court viewed the use of this land for organizing as a taking under the Constitution. And the last topic that I will dive deep into is the student-free speech. This case of Mahoney Area School District versus BI was decided on its implications for public employers. A public high school student brought this action against her school district, alleging that her suspension from the junior varsity cheerleading squad due to her use of profanity in a social media post that she made off campus and on a Saturday violated her First Amendment rights of freedom of speech. The cheerleader sent a Snapchat to some of her friends that used vulgar language and gestures criticizing both the school and the cheerleading squads. Another student on the squad ended up screenshotting this picture and sharing the picture with the two cheer coaches. There were several cheerleaders and other students that approached these cheer coaches and seemed visibly upset. And questions about the post persisted during an algebra class that was taught by one of the two cheer coaches. As a result, the school suspended the student for a year from the cheerleading team. This case relies heavily on a famous Iowa case from 1969, the Tinker versus Des Moines Independent Community School District. In this case, it gave schools a special interest in regulating on-campus student speech that materially disrupts classwork or involves substantial disorder or invasion of the rights of others. Tinker also showed that a school has ability to regulate a student's speech, and this does not just disappear when that speech takes place off of campus. So in Mahoney, the Supreme Court pointed out circumstances that may implicate the Tinker decision, which includes serious or severe bullying or harassment targeting particular individuals, or perhaps threats aimed at teachers or other students. Maybe less serious, when students are just cheating off of campus or on the weekends, this is still under the school's authority to regulate. Here in Mahoney, the school's interest in preventing disruption is not supported by the record, which shows that the discussions of the matter took at most 5 to 10 minutes out of the algebra class for just a couple of days, and that some of the members of the cheerleading squad were just upset about the content of the student's Snapchat. This alone does not satisfy Tinker's demanding standards of a material disruption in the classroom. And so therefore, the Supreme Court ended up holding that the school did in fact violate the cheerleader's First Amendment rights when they suspended her for that Snapchat. And that wraps up all of my discussion on Sierra and the Supremes. These cases are just a few examples of the ever-evolving employment and labor laws that we are seeing across the nation and in Iowa itself. As I mentioned, my name is Sierra McConnell, and I would be happy to speak with you about anything I discussed today, or if you have questions about anything else. I'll hand it back to Jill when she's ready, and we'll keep moving along in the seminar for you guys. Thank you.
Thank you, Sierra. That was supreme, if I do say so myself. It's time for a break, and we will see you back here at 10:10. Thank you. Welcome back from break. And do I have an exciting presentation for you? I could not be more pleased to welcome Desmond Adams to speak to you today about diversity, equity, and inclusion. Desmond is an attorney by education. He's an entrepreneur, he is an author, and he's a business owner. And he wrote the book, D&I Has Died. And you'll see this is my copy that is marked with little tags on it. Desmond is here to talk to you about a topic that he feels passionate about. And he has a company called Focus and Find, where he recruits to find diverse candidates for boards of directors and for executives at companies across the nation. So I am so pleased to introduce you, Desmond. Take it away.
Greetings. Hello, everyone. It's a pleasure to meet you. My name is Desmond Adams. Thank you so much, Jill. I greatly appreciate you inviting me to have the opportunity to talk about such a passionate project, a passionate initiative regarding diversity, equity, and inclusion. And I look forward to sharing that with your audience. Dickinson, again, thank you so much for your invitation. And I also want to say thank you to the support staff, to the team, because there are a lot of people behind the scenes right now. You only see me on this camera and you see Jill, but there are other people that are operating switches, lights, and everything in between. So I want to say thank you to them as well. And then I want to tell you, the audience, I have a lot of energy. Welcome back from your break. My goal is that what I share with you is the absolute best thing that you not only have heard today, but I'm hoping that what I tell you is the best thing that you've heard in 2021. And that's with only a couple of months left, and I hope we can carry it throughout the year. So get ready, strap in the seat, and let's go for a ride. What I have for you today is we're going to talk about diversity, equity, and inclusion recalibrated. That was the title of this presentation. So when we get into diversity, equity, and inclusion, clearly I wrote a book called D&I, D&I Has Died. How socially responsible board and executive search erases bias and drives profit. But we'll take time, we'll get to that. I'm going to have two big ideas for you today. I only have 60 minutes, right? That's all I have. So all I can really give you is two solid ideas. I think that these two ideas are going to add tremendous value to either you as an individual, you as an organization, you as a manager, or God bless America, as I like to say, just you as an individual. That's what I hope. That's my goal, and I'm going to hold myself to that. Hopefully by the end of this, send in a message or two and let them know whether or not I did a decent job, okay? Here we go. Idea number one. When we talk about diversity and inclusion, we talk about driving inclusive workforces. We talk about driving inclusion through our organizations. We always tend to try to find a way that we're going to talk about that. Whether it's the nice thing to do, whether it's the right thing to do, we can hug trees and say, you know, we can hold signs. These are all wonderful things, of which I agree with all. We can even talk about it's the spiritual thing to do, moralistically. We can make that argument as well. But the argument that I'm about to share with you, in my opinion, is an argument that is much stronger, much more valid, and far more impactful. Those ideas have been ideas that have been thrown around since before my parents were my parents. I'm hoping that with some of these ideas, these are not the same issues that my children's children someday have to deal with. Okay. So about 10 years ago, give or take, between 10 or 15 years ago, there's a thought leadership company called McKinsey & Company, right? They came out with a wonderful study. This study was a mathematical equation that corroborated and directly correlated increased earnings before interest, taxes, depreciation, and amortization, better known as EBITDA, with increased diverse leadership teams. Short point, McKinsey correlated that the more diverse your leadership team, that up to 33% higher EBITDA. Let me hit that point again. Diverse leadership teams have been found mathematically correlated by McKinsey & Company, one of the thought leaders in our nation, to directly correlate increased earnings before interest, taxes, depreciation, and amortization up to 33% higher with diverse leadership teams. So I want you to mark that. Now let's keep going. So today, our boards of directors are asking, our board of directors of our clients are asking our CEOs, right? What are we doing? How can we drive this? Where's the problem? What's the challenge that we're experiencing? The CEO's job, the chief executive officer, and I may fall into saying him a lot, my apologies, him or her, I would actually prefer it to be they. The CEO's role is going to be primarily three things: vision, mission, profitability. Vision, mission, profitability. That's the CEO's responsibility. The CEO has a job to maximize the profitability of that organization and that client if it's a for-profit business, is which I'm speaking of. I'm not speaking of not-for-profit. But a for-profit business, they have the responsibility to driving and maximizing profitability. Outstanding. Outstanding. They also have what? Mission and vision, right? The vision of the organization. Where are we headed? Are we driving and delivering upon our mission to our customers, to our clients, to our communities? Are we doing that? How are we doing that? That's probably why I'm in front of you today on this camera. So, as we identify that, let's continue down the path. We've identified that McKinsey & Company has stated this correlated degree. I've identified it that up to 33% higher EBITDA with diverse leadership teams. Now let's take it a little further. So when we talk about that CEO, whomever that CEO would be, let's start talking about something that they have to do. They have to maximize profitability. So how do we do that? Well, one would make the argument, and I make the argument in the book D&I Has Died, is the CEO driving their responsibility? Are they maximizing the profitability of the business if they do not have a game plan, strategy, and implement the driving of an inclusive workforce in their company? The argument that I would have would say, rather not. Again, I'm going to go back to McKinsey & Company, but this time let's add a couple of more players. Boston Consulting, this small company called Deloitte, have also supported, in addition to Harvard Business Review, HBR. So the reality that the correlation of increased profitability directly related to increased diverse leadership teams is now a statistical norm. So the question is going to come to the CEO of your organization if you're not the CEO. And it's going to come to that organization, and the question is going to be, if the CEO is maximizing profitability and doing their job, then how is it that their leadership teams are not becoming more inclusive? If leadership teams have already been determined, that's the key. It has been determined that the more diverse the leadership team drives up to 33% higher EBITDA, higher profitability, top line profit, then the question becomes, why are you shirking your fiduciary responsibility, CEO, by not driving an inclusive workforce? That's a significant question. That's a wonderful question that our friend Jill Jensen and the great attorneys at Dickinson, as well as other law firms across the country, are going to be talking to their clients about coming soon. The fiduciary responsibility that a CEO has to maximize profitability has been determined to gain greater traction by increasing your diverse leadership team. That's not a bullet point on increasing sales. That's not a bullet point on increasing marketing. That's not a bullet point on increasing advertising, which are all wonderful. It's not an increase in gaining the staff, more traction, bigger business, more people, less people, taller people, shorter people. No. The ability that a company has is already within their palm. The question becomes, how do I get to it? I told you I had two big ideas. How you like that first one? Okay, that's idea number one. I need some questions. That's hard. I'm talking to a camera. There's no energy here. I want to shoot some questions. Let's go some questions while we're talking about that. So now, I've laid that out to you, the 33% increase in EBITDA. I've laid out now why we need to talk about driving inclusion. I've laid out now, from a financial standpoint, why that makes sense. Now we're going to get into the big idea number two. I'm going to give you a quick second. Any questions regarding this point? No questions? Outstanding. All right. Either my energy has quieted the entire audience down, or you guys are just mesmerized and want me to keep going. I'll take the mesmerization. All right. So email questions to troosa@dickinsonlaw.com. Again, that would be troosa@Dickinson, I'm sure you know how to spell that, law.com. If you don't know how to spell Dickinson, go to your invoice. All right, let's keep going. Idea and point number two. Now, we're only about 11 minutes in, so that gives me roughly 49 minutes left. This point is going to take us about a half hour. I'm going to give you some ideas. I'm really going to be looking for some questions, okay? All right, so now we're going to go on a deep dive number two. Idea number two. So I wrote this book called D&I Has Died. That might be fascinating, seeing how I'm talking about diversity, equity, and inclusion recalibrated. Why do I say that D&I has died? Well, first, I need you to be intellectually honest with me. Do not be intellectually disingenuous right now. At minimum, don't lie to yourself, okay? At bare minimum, don't lie to yourself. D traditionally in our society is black and brown. That's people of color, people that look like me, maybe people that look like you or your neighbor. But typically D in diversity is considered as people of color. Well, we're going to skip the ampersand, that stands for and. D and I. The I is inclusion. Rocket science. Okay, what is inclusion for? Inclusion incorporates who? Gender orientation and sexual orientation. If not, it would have been included in D. But it's not, right? Let's go back 10, 20, 30 years. We used to talk about multiculturalism, right? We talked about just the word minority. Back then, women-owned businesses were part of minority-owned businesses in the early 90s. Then the early 90s, late 80s, they took women-owned businesses out of minority-owned businesses. It became minority-owned businesses and women-owned businesses. Then we get through the 90s. We have a wonderful president that gets in some stuff. We go through the 90s. We get to the back of the 90s. Now all of a sudden we're talking the sexual explosion again. Well, we actually had that, in the 70s and the 60s. But now all of a sudden we have it again, sexual orientation. We have to figure out another way to get it done. Diversity doesn't capture everything. That was the point. So we had to... All right. We're live? So they're seeing me talking right now? Okay. We're back. We're back. All right. I'm back. They didn't cut me off. I think that was the CIA saying that you're getting too close to home here. All right. Let's pick this up. I'm not certain where we dropped off with you. So what I'm going to do is I'm going to take us back to, really quickly, bringing us out of the D&I into where we're headed with the white men. That's okay. So we've already discussed the D&I has died. I'm sure you're with us on that. I was talking about the black and browner and the D, sexual orientation and gender and I. We have evolved to the fact that we're at D&I. Let me add this to it since we're picking this up. Let's add E. If D&I was really encompassing of everything, then why would we add E in the last 18 months, right? We added E in the last 18 months because we recognize that D ampersand I is not big enough. So D, E, and I, does D cover Asian Americans and Native Americans? I would argue no as well. Equity is not that. If anything, we're going to have equitable inclusion, but we already have enough letters. I'm thinking that pretty soon we're going to have X, Y, Z, T, W, A as well. So with that being said, let's keep it moving. Now let me get my flow back. So when we were talking about where I'll start to transition is to what everybody talks about, but everybody doesn't talk about, right? And that is, when I was looking at the magazine article, Why Diversity Programs Fail, Harvard Business Review, HBR, the white male managers were very supportive of the diversity and inclusion that their corporations were trying to achieve. However, the concern for those gentlemen was, as they looked over their shoulder, where's the opportunity for my son or my grandson down the line? Now, that's the question that people say but don't say. So we can either address what's really going to help us move forward, or we can continue to have our heads buried in the sand as if, things are just going to get better because they are. So let's be adults here, and let's bravely walk into this territory, all right? Let me take you back to my Star Trek days. Trek, okay? We're going to boldly move forward. The Caucasian man's concern from that article was a valid one. So how do we address it? Does D&I address it? The answer is no. Why do I say no? Because we added E in the last 18 months. So the answer is no. Does D, E, and I address it? I would also argue no. Because how does it include him? Now, this is really touchy. Well, Desmond, how can we bifurcate and do both? But the diverse community needs our support. They need our help. We need to right the ship. We need to make things really inclusive. I agree. But let's be intellectually genuine. How do we achieve that? How do we achieve it? So as I was building my company, and I did the research, and I looked at Harvard Business Review, I looked at McKinsey & Company, I looked at Deloitte, I looked at Boston Consulting, I looked at 20 years of research in the UK, how the UK has been able to handle the transition of gender-related roles in the C-suite or the boards. I looked at the laws changing in California in 2017 related to gender diversification on boards that are domiciled in the great state of California. I looked at corporate social responsibility. I looked at something that's called ESG, right? I did all this research. And then we settled on this as an organization. And that's what makes us the nation's only socially responsible board and executive search firm. We focused on social responsibility, and this is how we highlighted socially responsible. 1, all key stakeholders. 2, environment and culture. A sustainable environment and a sustainable culture. 3, sustainable business practices. 4, sustainable profitability. See, the entire D&I argument and initiative and purpose dies if we're not talking the language of the very institutions that are going to be seeking to become more inclusive. But you have to speak in a business way. See, earlier when I gave you the first big idea, the reason I gave you the first big idea was because I was talking in a what? A business way, business language, EBITDA, earnings before interest, tax, depreciation, and amortization, top line revenue, growth. That's business. I'm talking about capitalism driving inclusivity in your organization. I'm not talking about hugging each other, holding trees, and making each other feel good. I'm talking about driving revenue, capital into your organization. That's what we're talking about. I'm tying it into inclusive language. Woo, this is getting good. You guys are paying attention. Why am I talking about that? Because you need a way to be able to tell your team how they can get along, and it can't be tied into things that we've been talking about for the last 20, 30, or 40 years. It has to be about generating revenue because I care about the next person, man or woman, if they help me put bread, milk, and water on my table. If you help me generate profit to help my family, do you really think I see you for whoever you think you are? No. Let's talk about common denominator, lowest hanging fruit. How can we get along? How can we have a Switzerland, right? Switzerland has everybody's money but nobody's military. This is not rocket science. It's strategic thought. So now let's apply that social responsibility. Woo! Back to the D&I real quick. I'm taking a hiatus. I'm going to jump us somewhere, but I just got a feeling here. Let's take us back to the D&I discussion real quick with the socially responsible. If your system took all key stakeholders into account, sustainable business practices, sustainable environment, as well as community into account, and sustainable profitability, I think that we would impact our D&I message. How's that? I think we would impact the D&I message. Stay with me. Let's take D&I and let's do it in a socially responsible way. Now, I don't like D&I at all. I say eradicate the word altogether because I'm nobody's diversity. Good luck with that, but that's a different discussion. They got to bring me back and pay more money for me to give that to you. On this topic right here, let me tell you. As far as the D&I and the socially responsible goes, let's apply this to recruitment. There we go. Here's an idea. I don't know how much, I got some time left. So let's talk about how this applies, how this goes into our recruitment. Because I want you to walk away with some real talk. When we're talking about the recruitment process, and you're talking about driving a socially responsible recruitment process, ultimately you know what you're talking about. You're talking about a blind recruitment process. Let's talk tactics and strategy. Strategy, you're talking about a blind recruitment process. That means that no man, no woman, no person, and because your outcome is not driving a systematic way to achieve your goal. There's not a business in this country that doesn't invest in sales. No matter how wonderful your product is. You have to invest in the process to get the outcome. So when we talk about socially responsible recruitment, we're talking about a blind recruitment process. We're talking about a blind recruitment strategy. We're talking about taking the name, demographic information, regional information, educational information sometimes, off of that information that's seeable by whoever your recruitment person or committee would be. I.e., we're in the middle of the country right here. Our clients on the East Coast, education becomes a bias based on their predilections. In the middle of the country, we just want you to be educated. On the west side of the country, they come a little bit more casually to their meetings. Our people are different all over the nation. How is your approach driving a systematic way to drive it? So when we talk about that socially responsible recruiting, we're talking about blinding the process, blinding the slates. Let's get to here's another idea for you, takeaway. Let's get to a top 10. That top 10 will be blind. Sit down with your people. Someone in HR, outside party can sit down. In that 10, decide who are going to be your best candidates. At that point, after you've decided who are going to be your best 5, Uncover that. Then make the client aware. This can be done internally as well as it can be done externally. If you really need support, you can have an outside third-party organization provide that additional support, the same way that your lawyers provide outside support or your auditing team provides outside support financially. It's to insulate you from challenges that you may or may not bump into. Meet with them. Now, I'm going to give this to you as a bonus. If we want to be really sexy, we could have a double blind. What could we do then? It could be all the way blind until the top 3 are selected, and those top 3 are shown to the client. Now, how do you get to that far down the process? There's a couple of things I left out, of course, because we only have so much time. But one of the things I would say is it really depends upon your initial consultation that you hold with your client. Meaning, when you're talking to them, talk to them about their role based on how they see it, not based on a job description that's been lukewarm, written over, or drafted 15, 20 years ago. And then be very exacting. We use a statement called polka-dotted fish and striped catfish. I share with my clients that if my client is looking for a polka-dotted fish, a polka-dotted and striped catfish, if we find a striped one, we throw it back. That's how specific we are in our approach. Let me give you approach 2 inside of that. Another idea for your recruitment, socially responsible recruitment. Another idea for you. This really fits, let's say, if you have the need, or you care, or you're concerned, or as we talked about before, that fiduciary responsibility and the big idea is a major issue, and I can already tell you it's a major issue across the land. Then another one becomes, well, Desmond, we have the need to drive this inclusiveness through our workforce, but we really don't have the job today. We don't have the job for that today. We have a need, but not a job. We have a want, but not the need. In that instance, what I would give you an idea is something that we call Focus 365. That's what we call it. But I'll share in concept with you. In concept, you should create, build, and manage a separate pool of passive talent. Passive talent meaning talent that is not looking to leave. And then with that pool, maintain that pool for said duration of time. Let's say, i.e., a year. Why would the talent want to be in your pool? Because you're going to commit to having your board level or someone from your C-suite. If you're a law firm, a partner or partners. And what do? They're going to drive that. They're going to drive that because they're going to meet with the candidates every 13 weeks, every quarter. That way you can have an interaction with the candidate every quarter. And that interaction with the candidate, if we wanted to be socially responsible, this pool could be blind. If you didn't want to be socially responsible, the pool didn't have to be blind. But the blindness would help you, especially if you're dealing with passive candidates, because passive candidates are not looking for opportunities. That's why they're a passive candidate. But the passive candidates don't want to see other passive candidates. So if we're going to have a situation like this, that would make sense. That would be blind. Then you can meet with them in a video conference environment, something similar to this, where they don't see each other as well, but they see you. And they benefit from being in the pool because they have an opportunity to interact and build a relationship with someone at the board level or the C-suite. That lets them know that they are in a special pool. Now, how many different pools you have? That's up to you. I would argue the pool should be wrapped around whatever your discipline is that you're looking to build that pool. Now, in order to be in the pool, they should be interview ready, hire ready, and they should have a psychological assessment. Now you have reporting and insights. Those reports and those insights are valuable to you. Let's go back to big idea one. One of my largest clients, actually, in Des Moines, an insurance company. I'm talking to the CEO, and I asked them, what would happen, take a piece of paper. Oh, no, I'll do this. What would happen if a reporter grabbed a microphone and put it right in your face and said, hey, you made a commitment to diversity, CEOs, diversity in action. You made a commitment to this. You made a national commitment to that. What have you done? That costs money. That costs money. Let me tell you how that costs money. Now you have to pay your marketing team more because you didn't answer the question pinpoint. You've got to talk to your PR team because now they have to do crisis intervention because you weren't empathetic. Now you've got to talk to your outside general counsel because they need to make certain that legally speaking, you're squared away. Now you're going to go pay some search firm to go look at an outcome-based result. Look at how much money we spent. I'm glad you got big checks. Look how much money we spent. Lawyers got paid, we got paid, marketing got paid, PR got paid. Your brand takes a hit. Your customers are irritated. Your clients are looking for who your competitor is because you don't get it. Because your competitor has somebody like me that's saying, hey, big idea number one, CEO has a fiduciary responsibility to maximize profitability. That's already been correlated and determined that inclusive and diverse leadership teams drive up to 33% higher EBITDA. Why don't you have process, protocols, policies, and procedures wrapped around this to drive that? This time I'm giving it to you so you can write a check, actually. All right. Those are some good ideas. So now we're at 10:50. We're at 10:50. So I'm watching my time now. I think I have, we have left. Gracias, 20 minutes. Okay. Do I have any questions so far about anything that I've shared at troosa@dickinsonlaw.com? Man, I'm giving you guys better stuff than you're responding to. Okay. If we got it, I'm going to take a step. Let me do this. Since you guys don't have any questions, I gave you some good stuff. I gave you two great ideas. Let me drive it further for you. I'm going to grab a piece of paper. So I have this pad here. This is my presentation. Those are my notes. There you go. All right. Here's my pad. So what I'm going to do is we're going to use this piece of paper as an example. White piece of paper. I know it's got blue lines. Just let it be white. White piece of paper. Imagine we're going to have a string. We're going to take a string. We have one piece of paper. We have one string. String represents diversity. Paper represents organization. This is what we do today. Tell me if I'm wrong. Send in a question if you think if you got a question. This is what we do today. I'm going to give you two examples. We'll take this. I know you can't see it, but I'm rolling it up. 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 If we were in Colorado or another state, I would have made a joke, but I'm not. We're in Iowa, so we're rolling it up. Okay. We're rolling it up. Now, this is an organization with what they do today. Remember I mentioned we have this invisible string here, right? Just yarn. Imagine yarn, right? It's red, right? A red piece of yarn. Organizations today say, you know, we in this room right now that I'm in, there are 2, 4, 5 women and 2 men, right? We say that we care about inclusion. I already shot down diversity and inclusion, right? So we care about inclusion. And this is our organization. We care so much, we want you to come from the outside, give us do an audit with us, talk to our lawyers, figure out what we can do better. Okay, we come, we do that. What do? You take the string, you say, Desmond, thank you. You put the string here, and then you wrap the string like a candy cane. And you're like, hey, isn't this awesome? We got a candy cane now. We did it. We have our business and we care. So we wrapped around this candy cane diversity and inclusion because we care. Because our competitor, they don't have the string wrapped around theirs. So we're better. And that's correct. Bill, that's low-hanging fruit. That's what we do. No. This is what you do. You take the same paper, same company, same string, but this time, you don't insult women by saying, you know, we're going to add you to the outside of what we do. Because I really don't believe that you could do what I do. Now, they don't say that, but that's what they say. Let's get back. We're not going to insult women. So we're going to take the string, and we're going to take the string from this corner, and we're going to attach it that corner. So now we have the string. So what I'm going to do is I'm going to write, and I know you can't see this probably because this pen is so thin, but I wrote a line, and that represents the string. Now what do? I'm going back to rolling this thing, but since we're in Iowa, I'm not joking about that. Now we have the string throughout and not on the outside. See, what you really need to understand is that if we're going to talk true inclusion, then you can't placate people by wrapping outside yarn over a mess that has already been created. If you care about driving inclusivity through your workforce, focus on process, policies, protocols, and procedures. Are your process, protocols, policies, and procedures, are they fair? Are they gender specific? Are they truly open and available? Is it in word and word only? Is it in deed or word? Is it in action or word? Desmond doesn't want to be hired no more for being African American than I want to be hired because I'm a man. I don't want to be hired because I'm 6'5", 250 pounds. I had to put that on camera in case I lose weight. I don't want to be that's not what I want to be recognized for. I want to be recognized because I'm damn good. And I dropped out of high school, earned a GED from Job Corps, had a clerk internship for the former Chief Justice of the Iowa Supreme Court, Louis Lavarado, Don Nickerson when he was U.S. Attorney, God rest his soul, and even Judge Parker when he was in Indianola. Look at me for what I have accomplished and what I have achieved and what I do. Socially responsible action does that. It takes all key stakeholders in account. It takes environment and culture into account, sustainable business practice, and sustainable profitability. Let me give you another idea. I told you I was going to give you 2 examples. I'm running out of time. Let me give you 2 examples. I gave you one. Let me give you the other example. If you had a building, you have a building today. I'm in a building. You see these wonderful bricks that are behind me, right? This is awesome. This is real. You can hear it. Boom, 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 boom. That's a brick wall, right? If I hit it too hard, I'm going to hurt my hand like it's hurting right now. Brick wall. Okay. What connects this building? I'm giving this to the people that didn't get any of my other visionary stuff I gave you. What connects every room in this building? It's not the room. It's not the wall. It's the pipes and the wires in the wall. Woo! Good stuff, boy, good stuff. It's the pipes and the wires in the wall. You can't have a building and an organization and say to your female staff, yes, we really care about inclusion. We care so much, we built another room onto the house. But guess what? We didn't put any faucets in it. We didn't run any electricity in it. We didn't put any piping in it. But we have a room for you, and you're part of this facility. Is that clear enough? My house burnt down when I was in high school. I was a sophomore in high school. This is a true story. I was at a basketball game, and they came and got me at halftime. I didn't know what was going on. They came and got me. This was maybe, I told you I dropped out of high school. That was senior year. Go figure. Why do you wait to the end to do that? Anyway, different though. Junior year, I think I'm playing basketball. They come to get me. They take me home, and I'm riding in the back seat, and I see this big smoke, just billowing smoke, probably a mile or 2 miles away. And I'm like, wow, I had no idea. I didn't know that was my house, right? They didn't tell me what was wrong. They just said there was an emergency. I said, okay. We turn onto my block. I see the smoke. I still don't think it's my house, right? They can't get to my house. They have to stop at the end of the block. I'm walking. I recognize my house is on fire. Wow. And it was a 5-alarm fire. Meaning, cities from around the city I lived in, all those cities had to come. And go and figure what happened. You know why my house was on fire? Because we had a plumber, because we had an issue in our bathroom. The plumber was using a blowtorch fixing the pipes in the wall. And the spark off the pipe down below hit a wire. So the house was on fire for 2 hours while the man was working in the wall. And then all of a sudden, a fireball came out of the wall. Actually, first, the alarm went off, and my mother was like, I don't know why is the alarm going off? There's no fire. There's no smoke. What's happening? That set her off. And now my mother, being inquisitive, was like, what's happening? Next thing I know, then the fireball came out. Mom and gentleman were safe. My mom actually saved the gentleman, but they were safe. House burnt to a crisp. Are your walls on fire? Are your walls on fire without even knowing it? Outstanding. Are your walls on fire without even knowing it? That's key. Outstanding. We have a question that I believe somebody brought in. Excellent.
Okay, Desmond, this question says, I work for a nonprofit organization, and I believe that DE&I, at its best for us, will bring about incredible creativity that results in accomplishment of mission and vision. Can you share your thoughts about the way you might have this conversation with a nonprofit?
I think ultimately I think what we're talking about is the same for a not-for-profit in many regards. Maybe it's not driven on the fiduciary responsibility because for a for-profit business, the CEO has a fiduciary responsibility to maximize profitability, and that is the driving legal argument. That's the driving argument in order to make change from an inclusive standpoint in an organization. When it comes to a mission-focused organization, like you mentioned, a not-for-profit organization, that's more of a mission-focused organization. Absolutely, DE&I. I don't like the terminology DE&I, but I only don't like the terminology because I don't believe it's broad enough. But what I do think that you can do is drive a DE&I strategy in a socially responsible way, right? In a socially responsible way. So we're doing our diversity and inclusion in a socially responsible way, a way that includes all candidates, a way that includes all people, a way that also includes men. But I think if we're doing it that way, if we focus on the process, right? And I would talk about whatever your not-for-profit's policies, protocols, process policies, protocols, and procedures are. I don't know what those are, but I would say focus on those. Identify the fair recruitment in there or fair practices and try to make it a level playing field. Is it perfect? No. Is it the silver bullet in life? No. There is no silver bullet. There is no perfect because we are people and we are imperfect. So there is no perfect. But if we can create systems, the same way we create email marketing systems, sales systems, PR systems, Facebook, social media systems, the same way we can create systems to drive service, we can create systems to drive fair and inclusivity. The only way we don't is if you're dealing with intellectually deficient people. I have another question. Excellent.
Yeah, questions are flowing in now.
That's awesome. We're running out of time.
Yeah. Does the concept of equality support or impede socially responsible employment practices?
I do not believe equality impedes or impacts socially responsible recruiting practices. Not at all. Not at all. I think equality is exactly what we're talking about, right? We're talking about equality. We're talking about equity. We're talking about inclusion, and we're talking about diversity, right? We're saying we're not going to make one better than the other. We're not going to take one higher than the other. What we're talking about is we're going to be committed to taking everybody and the absolute best available and then driving it in a way that insulates client or executive or manager because they have a process to lean on. See, the challenge right now is that a lot of individuals are cherry picking what's of value or what's important to them. As long as we cherry pick, we will continue to have the issue. When you create blind processes, protocols, policies, and procedures that are fair, are equitable in distribution, you can report on that, you can base metrics on that, and is a systematic approach. Then guess what happens when Desmond loses the opportunity that Jill might have won? I'm okay. The problem is when either you believe you need to give me something, or I don't have a fair, right on, I see you, I don't have a fair opportunity. At some point, we have to become big boys and big girls and big others. These are real conversations that have real impact. We can put our head in the ground and we can focus on what has already been done. We can continue to say D&I because it feels good to us, because you know what? Brown and black, LGBTQI and orientation because it's easier. We can continue to leave out Asian Americans. We can continue to leave out Native Americans. We can continue to go about not having a process. We can continue to go about not having protocols, policies, procedures. We can continue to go about not having wiring and not having piping in our walls. We can continue that. All I would say is get ready to write a check. Because those ways of the past are not working moving forward. What I'm sharing with you is the way forward. Society will get to a point, they're already coming to a point. We have to include Caucasian men also in what we're doing. We have to include men in what we're doing, but yet we still need to make sure that we make way for people of color and gender difference as well as sexual orientation. That is why I say socially responsible. I'm not saying kill your DE&I program or initiative. I'm saying drive it in a socially responsible way. That way that the people that are on your team no longer have to look at the person left of them and say, you know what, are you here because of an outcome? Or are you here because you're adding revenue and money to my own pocket? Remember, the key for all of this moving forward is for us to be able to get along. Where can we get along? On profitability. That's where we can get along. That's why it's the fiduciary's responsibility. If we're in a not-for-profit world, I recognize it's not a mission. Profitability is not the mission. But when we're talking about systematic approaches, that is. Excellent question. And I think that I am about out of time. I think I got like 3 minutes left. If there's any questions in this last 3 minutes, I could talk about this till I'm green in the face. I eat, sleep, and drink this nationally with national leaders. So if there's any other questions that you may have. None. Well, with that being said, I want to thank Dickinson Law. I greatly appreciate it. The opportunity to come speak with you today. I am so incredibly proud of you being a law firm that I have worked with and will continue to work with. It's wonderful to get in front of the issue versus to always operate behind the issue. And for everyone that's listening to this call, please take the 2 big ideas. Where you're at on the D&I, so be it. The book has some more argument in there. But the big idea about fiduciary responsibility, socially responsible recruitment for pools, and systematic ways to drive inclusion in the workforce so that we can all make more money and ultimately heal this great country of ours. Have a wonderful rest of your day. Thanks for your time today.
We're going to take a little short break here. Thank you so much, Desmond. That was wonderful. And we're going to get set for our next session. So just a couple minutes. Welcome back. And we have a fun session for you with 2 of our shareholders in the labor and employment section who have a personal connection to this topic. We're going to talk about pregnant applicants and employees and the law surrounding that, what's currently going on, as well as what's happened in the past and what you need to be paying attention to. First, we have Melissa Schilling, our newest mama, who is still technically on maternity leave, but here today, coming specially to you to talk about pregnant applicants and employees, joined by Regan Wilson, also one of our newer mamas. I think Regan's baby is a year old, is that right? Yes. Yeah, okay. So we've got twins for Melissa who are 2 months old, and we've got a year-old for Regan. So these new moms can really tell you where it's at. Take it away, ladies.
Thank you, Jill. My name is Melissa Schilling, for those of you who don't know me, and this is Regan Wilson to my right. Today what we're going to be talking about is a lot of just common sense, but unfortunately I still receive calls from employers who have messed up or who are on their way to mess up and will potentially discriminate against a pregnant employee or an employee who just had a child. For instance, a lot of time I get a call and they say, you know, this woman that I just hired just told me she's pregnant. I don't want to deal with her anymore. So how do I get rid of her? Okay, that's a scenario we're going to talk about today, and it's a question I get frequently. The same is true for women coming back from leave, an employer upset that she has to take additional time off, maybe to pick up a child from childcare or something like that. One thing that I think is really important in this day and age where there's a significant labor shortage is that employers treat all employees right, but also treat pregnant and new moms right. Because if you want to attract and retain good employees, treating them right and not being critical of them is kind of the way to go. So the agenda for today is we are going to talk about a number of laws that apply to pregnant employees and pregnant applicants, as well as new moms, and also real life scenarios. With the laws that I've listed out here, one of them that I forgot is the Americans with Disabilities Act, which applies to employers with 15 or more employees. And we're going to go over that a little bit in more detail as we go over these other laws, but just take that into consideration. Now, there are really two components to the laws that I've listed. Not every law has both of these components, but together they do. The first component is that some of these laws require employers to provide a leave for pregnant women or women who are experiencing medical conditions related to their pregnancy. The second component is just what you do with pregnant women and the fact that you can't discriminate against them because they are pregnant or have some sort of medical condition. Before we get really into the deep dive of these laws, Regan's going to go over what she's seeing with the Biden administration and new federal legislation potentially.
All right, so for those of you who do not know, part of President Biden's Build Back Better Act included the Paid Family Leave Act, and that would be giving employees 12 weeks of paid leave for employees who are experiencing childbirth or need a leave of absence for childbirth, employees who are taking care of a sick relative, and then employees who are addressing their own serious medical condition. And the way that that would work is that the federal government would be paying for that paid leave. The United States of America is actually one of 6 countries that does not actually have paid family leave, so this is something that is a very big hot topic. And then the pay for determining what to pay these employees would be determined on their recent work history. Now, last week, President Biden actually pulled that from the plan because it has received such backlash from some of the more moderate Democrats. But then just as of yesterday morning, it sounds like it's back into the legislation that they are going to be trying to pass, except now it has been pared down to potentially four weeks of paid leave, but it doesn't necessarily have to be for childbirth or taking care of a sick loved one. It's really just blanket 4 weeks of paid leave. And with that piece of legislation, also the federal government would be paying it. And we will see if that gets passed or not. It sounds like West Virginia Senator Joe Manchin is kind of the challenger to that, so we'll see if they can get him on board and whether we can get some paid family leave.
Yeah, I think eventually, I have to make a prediction. I think eventually the United States will have some form of paid leave. I think it's just a matter of when and at what point in time, and as well as how much. And Regan, in your research, did you find if it would apply to all employers or certain size of employers?
Yeah, I think that was the interesting thing. I'm not sure about what they proposed yesterday as far as paring it down to 4 weeks, if that would change, but the big deal of it was that it would apply to all employers, so even those with very small companies. But then also, there are several states in America that have paid leave already.
Let me guess, California is one of them?
Yes.
Okay. All right. So let's go ahead and move on to the first law that we're going to talk about today, which is the Pregnancy Discrimination Act, PDA. This act was actually in 1978, Congress passed this act, which amended Title VII. So if you hear Regan or I refer to Title VII today or PDA, essentially they're interchangeable here. The PDA applies, or in Title VII applies to employers with 15 or more employees, and it prohibits employers from discriminating against employees on the basis of their pregnancy or pregnancy-related medical condition. Now, for you extra small employers out there who may think, well, I'm off the hook and don't have to comply with that, we'll stop right there, because the Iowa Civil Rights Act has a similar provision. And as we will discuss later on today, the Iowa Civil Rights Act looks to federal law to interpret its own law. So the concepts I'm talking about now will also apply to you smaller employers. Now, what does it mean that you cannot discriminate against employees that are pregnant? Well, the law specifically states that you essentially have to treat women affected by childbirth, pregnancy, or related medical conditions the same as other employees that would have something impacting their ability or inability to work. Before I dive into this, I just want to note that I probably should not have used the word woman when I wrote out this slide. As we've discussed in prior seminars, the use of gender-neutral words are becoming more popular due to recent cases involving gender identity discrimination. Whatever your political views are on that point, I just want to highlight that issue for you. The other thing I want to highlight is that I recently saw where there was a transgender person who was biologically female, was biologically female, yeah, but identified as male and became pregnant. So the question is, well, does the employer have to, do these laws basically apply to that type of person? And the answer to that is likely yes. So just kind of maybe a forefront issue that you need to be aware of. When it comes to this stuff, a lot of times I also get questions from employers where they're making decisions based upon assumptions or stereotypes. And the EEOC has specifically stated, do not make decisions based upon assumptions or stereotypes. So for instance, I have this woman in her childbearing years, and she works with chemicals. Well, I'm afraid that if she wants to get pregnant, the chemicals could harm her fertility or the baby. Well, that's an assumption or a stereotype that might not be used to reassign that female. Or another example we're going to talk about later on today is, oh, this job is too stressful for this pregnant woman, so she should work in a different job. That is an unlawful assumption and would be considered as discrimination under the Pregnancy Discrimination Act. So let's go ahead and talk about, Regan, can you talk about what protected classes are?
Yes, protected classes include an employee who is currently pregnant, an employee who has a past pregnancy, and I think that's more of a temporal thing. If you have an employee who just came back from maternity leave and you terminated that employee, then that would definitely fall within the Pregnancy Discrimination Act. The other classes are potential or intended pregnancy, and there are subclasses under that. One is reproductive risk, and that is like the example that Melissa just shared, where you cannot tell women employees, you cannot do this job because we're worried that it would harm your fertility chances. Other ones include discriminating against an employee who intends to become pregnant, an employee who is receiving infertility treatments and has to miss some work because of that. And oddly enough, you cannot also discriminate against someone for whether or not they use contraceptives. And then the last category is medical conditions related to pregnancy or childbirth, and that would include lactation and breastfeeding, and then also abortions.
Okay, so what, beyond just simply not discriminating against a pregnant woman or a pregnant person and or someone with a pregnancy-related medical condition, and by the way, when I say discrimination, I'm also including harassment and retaliation in that. But what are your obligations beyond just not discrimination? Well, do you have an obligation to reasonably accommodate the pregnant person if they're unable to do their job? Not necessarily under the Pregnancy Discrimination Act, but here comes the Americans with Disabilities Act. And like I said earlier, it applies to employers with 15 or more employees. But again, the Iowa Civil Rights Act applies to even smaller employers. So everyone should be listening here. Under that act, you would be required to accommodate a pregnant person if their pregnancy was considered a disability. So again, that would be a disability under the Americans with Disabilities Act is when a medical condition impacts one or more of the substantial life activities. So sleep, work, walking, whatever it may be. Examples, gestational diabetes or preeclampsia. Some women have to go on bed rest for various medical reasons prior to childbirth. So an employer would be required to go through what's called the interactive process to provide reasonable accommodations. You know, one thing when I was pregnant, I was swollen like a whale. And, you know, I didn't have to ask for accommodation, but I'd put a little stool under my desk so I could lift my feet up. So at the end of the day, I could actually fit into my shoes.
You're parking.
What?
You're parking.
Oh, parking. I was able to get a special parking spot because, again, I was a whale and could barely breathe after going up a flight of stairs. So, you know, those are just potential accommodations, giving someone a stool, giving someone a special parking spot, adjusting their work schedule. Let's say they have super severe morning sickness in the morning. You could adjust their work schedule so they come in later in the day and stay later at night. Those are all examples of how you can provide accommodations. And again, with the ADA, you don't have to give them the exact accommodation they want, but something that would relieve them or allow them to work and perform the essential functions of the job. Now, light duty isn't necessarily an additional obligation under the Pregnancy Discrimination Act, but it would be an analysis similar to reasonable accommodation under the ADA. So for instance, let's say you have a police officer who's pregnant and can no longer work on the streets. Maybe she gets a desk job for the last few months of her pregnancy. Something like that would be considered light duty. Then lastly, there's two different types of leave. Now, the Pregnancy Discrimination Act does not actually require leave for your pregnancy or what I'll call parental leave, but it does tell employers what your obligations are if you do provide this type of leave. So first, let's talk about pregnancy-related leave. So if you provide leave to a pregnant person, you know, you're going to be required to do that under the FMLA and the Iowa Civil Rights Act, which we're going to talk about later. But let's just talk about, let's say you provide leave to other people with medical conditions. You have to treat pregnant persons the exact same. So if you allow, let's say there's an attorney in my office who had a heart attack or some heart condition and had surgery, and he was entitled to 12 weeks of unpaid leave for that issue or up to that amount. They would be required to provide a pregnant woman the same amount of leave for her medical conditions. The same would be true if the firm required that person to use PTO to cover the leave. They would also should allow me to be able to use PTO to cover my leave. Then parental leave. So parental leave isn't related to a medical condition. It's essentially what you provide to employees to allow them to bond with their children or take care of their children. Now again, this law does not require you to provide parental leave, but if you do provide parental leave, you have to provide the same amount to fathers. So let me give you an example, or to men. So let me give you an example. Let's say that your business provides 8 weeks of unpaid leave to pregnant women for their pregnancy, and an additional 4 weeks of bonding time or parental leave to the woman. You would likewise have to give fathers that additional 4 weeks of bonding time, or I guess just 4 weeks of bonding time. Okay, so let's go ahead and go to the The FMLA, or no, let's talk about risk of non-compliance. Sorry, Regan, for skipping over
that's
you
okay.
there. So what happens if an employer does not comply with the PDA?
So you got it, a lawsuit is coming your way. And one of the remedies that the court can order is injunctive relief, having your workforce train employees, or I think possibly even reinstating an employee. And then of course the monetary damages such as back pay, emotional distress pay, attorney fees, court costs. And actually under the PDA, they also could get punitive damages for very egregious violations.
And when I talk about lawsuits with my clients, not only are you on the hook for attorney's fees for the plaintiff if they were to win, but then you've got to pay your own attorneys. So you're looking at hundreds of thousands of dollars potentially, because the plaintiff firms in Des Moines area or in Iowa really rack up the costs when it comes to suing employers. So their billable rates are like $800 an hour when they go to the court after a lawsuit is won and say, for every hour I worked on this case, I want $800, and they're getting that. So don't discriminate not only against pregnant women, but also just in general, because that is a big issue. All right, so Family Medical Leave Act. Now, the Family Medical Leave Act will not apply to a lot of people on this phone call or on this webinar, but it does apply to employers with 50 or more employees within a 75-mile radius. And it requires employers to provide unpaid leave to eligible employees to care for a child. This could be bonding leave. It also requires leave, that unpaid leave for pregnancy-related medical conditions, as well as to care for a sick child. And it also requires leave for adoption or foster care placement, which I forgot to put on this slide. The important thing to note that's not on this slide also is that fathers are entitled to the same types of leave. So this is not exclusive to moms or persons that are pregnant or become actually have the child. So keep that in mind. You also, not all of your employees will be eligible for FMLA. So in order to be eligible for FMLA, an employee has to have worked for the employer for at least 1 year and have worked 1,250 hours in the year preceding. If you are covered by FMLA, I'm sure you've heard our presentations before on FMLA specific. It's a very complex area, and we're not going to get into the complexity there, but I just wanted to give a brief overview. And Regan, why don't you talk about the risks of not complying with the FMLA?
Kind of like the PDA, you're going to have a lawsuit filed against you if you are in violation of FMLA. Some of the damages that could come your way would be lost compensation for the employee in the form of back pay or front pay, injunctive relief like we talked about, reinstating the employee or promoting the employee, attorney fees and expert fees, and then actually under the FMLA, the employer could be assessed punitive damages as well.
Okay. Next slide is actually our secret word, lullaby. So write that down and make sure you put your name in for a drawing, or yeah, I think that's what we're doing. Okay. All right, Iowa Civil Rights Act, ICRA. Now this law prohibits discrimination, harassment, and retaliation on the basis of pregnancy, and it applies to employers with 4 or more employees. Again, the concepts we're going to talk about here, I'm not going to repeat every little thing, but they're very similar to the PDA. So Regan, what are the protected classes under the Iowa Civil Rights Act?
So similar to the Pregnancy and Discrimination Act, but not as specific, the ICRA protects persons that are pregnant, persons that have had childbirth or are recovering from childbirth, and then miscarriage, also legal abortion and recovery therefrom, and related medical conditions to childbirth.
So unlike the PDA, the Iowa Civil Rights Act actually considers pregnancy to be a temporary disability, so that's important to keep in mind. So let's talk about what the employer's obligations are beyond just not discriminating. The biggest thing here that is often missed by employers is that the ICRA actually requires employers to provide up to 8 weeks of unpaid leave to employees that are pregnant or have pregnant-related medical conditions. So if you don't provide at least that amount of time, let's say you're a really small business, you have 5 employees, and you don't provide any leave to people, you would be required under this law to provide up to 8 weeks of unpaid leave. Now that has to be supported by a medical doctor's certification. You can at least require that. But you will oftentimes, if you have your handbook reviewed by us, we will stick this provision in there to remind you, hey, you need to actually provide this type of leave. Regan, why don't you talk about risk of noncompliance with the ICRA?
There's injunctive relief, reinstating the employee, and then of course the monetary damages that can come your way, such as court costs, attorney fees, wages, and emotional distress damages.
All right, so now on to the Fair Labor Standards Act. Now the FLSA applies to most employers. What we're going to talk about here is just a very specific break time requirement, and that applies to all employers that would be covered by the FLSA, except there's a narrow exception, and that is for employers with less than 50 employees if they can show that there's an undue hardship for providing this break time requirement. And essentially what this requires is that the employer provide reasonable break time for an employee to express their milk. And Regan, why don't you go over the rest of what it requires?
It requires time for your employee to have breaks for expressing milk up for 1 year after the child is born. And it has to be a private place free from intrusion and shielded from view of others, and it cannot be a restroom.
So what doesn't it require? The FLSA does not require you to provide paid breaks unless you already provide paid breaks to employees. So a lot of employers will provide 2 15-minute breaks to employees throughout the day. So those 2 15-minute breaks would have to be paid for an employee expressing milk. But if she or he or she needs additional break time, those could be unpaid breaks. It also doesn't require you to provide, a room with a window view, and it doesn't require you to have a permanent room dedicated to lactation. Instead, when you have a nursing mom, you set up this room. Regan, what are the risks of noncompliance?
We have a question.
Okay.
If I could break in real quick. Someone wants to know what happens if both parents work for the same company. Do you have to allow 12 weeks for both parents, or can you split it, legally speaking?
So this is under the FMLA. I believe this question is falling under the FMLA. So first of all, you have to be covered by the FMLA to even be required to provide the 12 weeks of unpaid leave. In that situation, you don't have to give the mother 12 weeks plus an additional 12 weeks to the father. In that situation, they'd have to share it. Under Iowa law, fathers are not entitled to that 8 weeks of unpaid leave. That is specifically for pregnant persons and persons that give birth to the child. So in that situation, the fathers would not be entitled to any of the leave. Okay, so yeah, go ahead and go into risks of noncompliance.
Under the FLSA, you can actually have the Department of Labor coming after you for this, and they can ask for lost wages. And then you can also do private suits asking for lost wages, attorney fees, and court costs.
So Regan, why don't you go ahead and kind of just summarize what we just went over?
All right, you cannot discriminate against pregnant employees or applicants. You cannot retaliate against pregnant employees or applicants. Covered employers must provide 12 weeks of unpaid leave under the FMLA to eligible employees. Covered employees must provide up to 8 weeks of unpaid leave under the Iowa Civil Rights Act for eligible employees. Well, I guess it's all employees, but it has to be
pregnant or actually give birth to the child.
Correct.
Yep.
And then covered employers must provide break time in a private place for employees who need to express milk.
Okay. And one thing that would be great to do if we are actually live in person is I want to kind of see what trends everyone else or what they do in terms of actual paid leave for employees. Trends I'm seeing are just all over the place. I've seen as high as 4 months of paid leave for men and for fathers and mothers. I've seen as little as no leave, or it's all unpaid leave, and it really is all over the place in terms of paid parental leave. Go ahead, Tiff.
Sorry,
okay.
we got a couple more questions.
Okay.
Nursing mothers, it states you have to provide a private location to express milk, but what if they don't own the facility? For example, we're a cleaning company of multiple client locations. We don't have control over their facilities. What's our responsibility to comply with these guidelines?
So in that situation, I would either work with your clients, whoever you're providing cleaning services with. I would also work with the person who needs to express milk. I don't know if a car would be a proper place because it's not very private. I mean, I would not want to express my milk in a car. But try to work with someone to set up that room. If it is a cleaning company, maybe they go in there after hours and they're able to go into a private room, shut the door, and express milk that way.
I know we're running out of time here, but someone would like you to repeat the employer's obligations to provide paid or unpaid breaks for employees who need to express milk.
Okay. So under the FLSA, which applies to almost every employer, you are required to provide employees that are expressing milk with breaks to express milk. If you provide employees with paid breaks, the breaks for the person expressing milk must also have paid breaks to express the milk. But that can be limited. So my guess is you don't provide unlimited paid breaks to your employees. So let's say you just provide 2 breaks throughout the day to employees, paid breaks. The lactation lady would get 2 paid breaks plus an additional 3 unpaid breaks to express milk. So yeah.
One more quick one.
Okay.
Does the that requirement, the nursing mother requirement, is that for hourly employees or non-exempt employees?
It is so hourly and non-exempt are essentially the same. It is actually just for them. I would recommend also giving your exempt employees the same rights. So yes, you do have to do that. The other thing I want to say about the breaks thing is that if you let your employees randomly take smoke breaks and they're all paid, and you're refusing to give paid breaks, the same amount of unpaid breaks to your the person expressing milk, you're going to get in trouble. So just make sure that you keep that in line. So the last thing I want to cover is just to make sure that employers aren't asking the wrong questions during interviews or saying the wrong things to women. So Regan, could you go over quickly what not to ask during interviews?
Do not ask the prospective employee if they are pregnant. Likewise, do not ask if they are intending to get pregnant or if they're wanting to expand their family, and questions along those lines.
And the law doesn't specifically say in it, do not ask these questions, but the EEOC has come out and said, if you ask those questions and there later is a charge of discrimination, we're going to look at those questions that you asked and use it as evidence of discrimination. Likewise, don't make statements that are critical of someone that is pregnant or who has taken leave. So don't say, oh, it's inconvenient that she's going to be on leave at this point in time. Again, those types of statements can later be used as evidence of discrimination. That's all we have for you today. I hope you enjoyed it, and I look forward to getting back to work here in a few weeks.
If you have any questions, our email addresses are on the slide. Thank you.
Thank you so much, ladies. And it was great to see Melissa. It's the first time I've seen her, and she is coming back in early December, so you all can start calling her again. And I don't know about you, but baby's hungry, and so maybe baby needs a little nap. So I think it's time for lunch, and we will come back and meet with you at 12:40. See you soon. Welcome back to the Dickinson Laws Employment Law webinar. I hope you had a good lunch and a little time to rest, if not catch up on emails. And now Brian O'Neill is here with me.
Hello, Jill.
Hello, Brian. And we are going to battle it out here in the Battle of the Bands, talking about restrictive covenants, non-competes, non-solicits, as they are more commonly known. All right?
You excited about this?
I am so excited about this
Good.
Battle of the Bands. I know you have a favorite band. I do not. I can't pick one. So it's going to be the battle of the name and the no-name band. All
Fair
right.
enough.
Okay. All right. First, we want to just give you a little groundwork about the types of restrictive covenants we're talking about. And restrictive covenants is this umbrella term that we use to encompass all of these kinds of things that we want to restrict our employees from doing both during their employment with us and even after their employment with us ends. So the first is the most common, and it is the non-compete. And this is where you identify what your business or your industry is, and you try to keep the employee from working in that industry after they leave your employment for a certain period of time. That is the most serious and strict kind of restrictive covenant that we have, and some employers don't like to include them in their agreements. I always include them for at least during employment, that you can't compete with me while you're employed with me, and you'd be surprised. We have definitely found employees
Definitely have seen that.
who compete with their employer while they're employed. So it's a good idea to have that in your restrictive covenants. Brian's going to talk about conflicts of interest. Are you?
Advance the slides.
This doesn't control it. They're controlling the slides. So
I
you want to see it? Okay, there we
Thank
go.
you.
Technical.
Technical issues, if you will. So contained within the restrictive covenants, oftentimes, if not all the time, we're going to have conflict of interest provisions in there, which essentially means similar to not competing during your employment, that you cannot have a conflict, a business-related conflict with your employer. Again, you'd be surprised how often it arises. Typically, when I see it, it's at the beginning of an employment relationship or towards the end when an employee has already made the determination that they're going to be leaving or that they see the writing on the wall. But those are typically when we see the conflict of interest provisions come into play.
Another place where I see them is sometimes with nonprofits. They feel like, a non-compete is a little bit too harsh of a thing for a nonprofit, so sometimes we kind of call it a conflict of interest. The other place I see it is with independent contractors sometimes, is rather than having a non-compete with them, we have some, you can't take on competing projects within our industry or doing the same kind of thing you're working on for us. Non-solicitations is the next type. This is really the most common, and I think this is the most enforceable, especially in Iowa, but it's always hard to prove though. So a non-compete can be pretty easy to prove. You're either working for a competitor or you're not, right? But non-solicits are kind of hard. Did you really solicit my client and take them away from me or not?
You need some help from your customers.
You do need help
Or
from
you need
customers.
them to leave, and then you need to figure out what's going on.
Right. And what's the problem with getting customers involved in your fights with your former employees?
They never want to get involved in the food fight.
No, they do not want to get, and you don't want to get them involved, right? So it's kind of a tough one, but we do include these in agreements for protection. So we include both protection of not soliciting your customers as well as your employees, because your employees are a valuable asset of the company as well, right?
Right.
Okay. So what about non-disclosures?
Non-disclosures essentially are reducing to writing the things that you don't want that employee to talk about or to discuss if they do leave, or even when they are there. So for instance, you would not want your employees, when they leave, talking about all of the things, the business plans and practices that you have in place, sharing client lists, sharing client confidential matters. So what these portions of the restricted covenant are going to do are prevent that employee from sharing those, again, during the course of their employment and after their employment as well.
Right. Non-disparagement agreements, we include those in a lot of our restrictive covenants, as well as sometimes severance agreements or separation agreements. And, defamation is the law, so you can't defame your employer or individuals, but disparagement is a little bit, we're kind of raising the bar. We're saying, you don't have to go as far as defaming us, but if you do something that just hurts my reputation as a company or my products or my services out in the marketplace, We're not going to have any of that. So we can include non-disparagement clauses. There isn't a lot of law about non-disparagement clauses out there in Iowa or in other states, so we kind of take the risk and include them in our agreements. It's sort of like we're not asking for permission, we might have to ask for forgiveness later.
And I don't know about you, I haven't seen a lot of instances where that's come into play, where we've gotten into litigation over the non-disparagement provisions.
I have not. I have seen, you know, a lot of employers get upset about things that former employees say, but we've never taken it to the point of litigation just over that.
Right, right. The next portion would be IP protection, so inventions and works. Again, this is outlining exactly what the employee owns or more likely does not own and what the company owns. So a lot of times these provisions are going to just make very clear that if you invent something while employed with the company and it's in the company's line of business, that is not yours. That is going to belong to the company.
Right. Yep. And the same with copyrights.
Same with copyrights.
Right. Okay. So I pointed out earlier that when you have a restrictive covenant in place, and we actually recommend them, we're seeing them in lots of industries more and more, they would cover your employees what they do both during your employment and what they do after your employment. And the time period after the employment we'll talk about in a little bit how long that can be. Brian, what about for-profits and not-for-profits? Is it okay to have a restrictive covenant at a not-for-profit?
In a not-for-profit,
Yeah.
it can be, absolutely. There are donors that maybe you want to remain with the particular not-for-profit that you don't want, if that employee leaves, sharing with their new not-for-profit. So absolutely, they can be for-profit and for not-for-profit.
That's true. And they can also be for employees and independent contractors. So most states allow you to have restrictive covenants with independent contractors. Not all, so, but Iowa is one that does. So we do recommend that. So we have one polling question for you guys, and you have a reaction button on your screen. And we want you guys to tell us how many of you use restrictive covenants with your employees. And it might not be with all of your employees, it might just be with some of them. But give us a thumbs up if yes, you use restrictive covenant, and a thumbs down if no, you're not using any restrictive covenants right now. And Sarah's going to monitor that for us, and Tiffany's going to tell us what kinds of results we're getting. Give it a couple seconds. No results? No one's reacting. 0.
We should have put a thumb there that's just in the middle.
We should have.
Right.
It's starting. Oh, it's like neck and neck.
I'm glad we called this Battle of the Bands.
You're right. So slightly edging out is using restrictive covenants.
No, we're back to a
No,
tie.
we're back. Oh, geez. This is quite a battle.
We should have set a time limit.
We should have.
Call it at a tie.
Calling it a tie? Okay, Tiffany's calling it. She's calling it a tie. So as we said, we recommend them in lots of situations. So if you haven't been, if you don't have them in place, thinking about them, you're just not quite sure, give us a call. We'll talk through them with you and see if they would do you some good. When it's too late to have them, when you have an employee who's left you and has harmed your business, then you're going to want them. So it's better to have them in place in advance for prevention than to wait till the end. So Brian, what kinds of things can employers legally protect with restrictive covenants?
So the first thing that's on there is trade secrets, and the restrictive covenant obviously will cover things that a business may have as a trade secret, but just stepping outside of the restrictive covenant setting for a second, there's protections for businesses at law. So there's the Federal Defend Trade Secret Act, and the state of Iowa has the Iowa Trade Secrets Act. So there's protections at law both here in Iowa and federally. So you might think, well, I don't need to have that in there. Well, you probably should have it in there, even though there's laws that protect against an employee from using trade secrets. You want to identify specifically what that is. Now, there's a legal definition of what the trade secret may be, but you can help clarify that in your restrictive covenant about what that trade secret might look like. The other thing is you want to identify what is it specific to your business that you want to protect. I think that the biggest thing that I see in terms of a protectable interest would be almost every business is going to have some sort of customer list or donor list or some list that's contained in a, for instance, an Excel document where it lists names, phone numbers, addresses, you want to keep that protected. You don't want that out to the general public. Now, who a person may, let's say, bank with, for instance, that might be something you could figure out pretty easily, but the fact that a list is put together in one nice, concise document listing everybody out, perhaps even amounts in an account or amount that a particular client may spend with your business, that's all information that you don't want getting out into a competitor's hands. So those are probably the biggest things that I see when there is a dispute about has something been taken or is an employee in violation of their restrictive covenant. That's where I'm really seeing, and I think you and I have been on a couple cases together where we've seen that.
Yeah, we definitely have. You also want to, of course, protect your relationships. So not just the data that you've compiled together about those relationships, but the actual relationships themselves, right? So that's another interest that you that a restrictive covenant is going to get for you. It's going to get you that protection that you are not going to get anywhere else, because even though there are trade secret protection laws, there are not those same kinds of statutes that protect your customers and your employees from being poached by other competitors.
And that's where the non-solicit's going to come in.
Exactly, exactly. And then, of course, lastly, the goodwill of your business, that kind of amorphous, reputational stuff that we talked about maybe with things like non-disparagements.
Correct.
Okay, great. So, Brian, why don't you talk to us a little bit about these restraints? We said earlier that, post-employment you can have a certain time, and we didn't talk about what that was. So put a little flesh on the bones for us.
Can you advance that?
Yep.
Thank you. So just because you have a restrictive covenant doesn't mean you can do anything you want. It is not unlimited in scope. There has to be some restraint on that restrictive covenant. That's by court rulings, and that's also sometimes by state law, depending on what state that you might be in. So there's got to be some reasonable restraint on what is contained in that restrictive covenant, and it's got to be reasonable in terms of time. So for instance, if I don't want you to compete against my business, you can't work for a competitor for a set period of time. Typically in Iowa, I think what we see most is 1 to 2 years. I know courts have suggested that in some circumstances it can go beyond that, but I think to be safe, usually it's going to be in the 1 to 2 year range. And for your business purposes, it might just be maybe you only want it for 6 months because of the nature of the contacts that particular employee has had. But again, usually that 1 to 2 years is what we're seeing. So you can also have a restraint in terms of geography and in terms of customers. So first, let's talk about the geography. If you want to have a non-compete in place, you can have that related to the nature of the employee's work for your company. So what I mean by that is, if I work for your company and you only do business in Polk County, it would be reasonable to have a restraint for sure in Polk County and perhaps maybe in immediate contiguous counties as well, so that you don't want me competing just right outside of county line, but maybe I'm still generally competing against you. So that would be reasonable restraint. But again, it's about the nature of that employee's work for your business. So if you have an employee that truly is doing nationwide work for your business, it could be reasonable that you restrain that employee from working for a competitor and on a nationwide scale. Now, I've had clients come and say, well, I just want to have it as broad as possible. Let's make it nationwide. Look, if your employee and your business is only focused in Iowa or a particular market in Iowa, trying to broaden that out to not allowing that employee to work in that particular industry nationwide, it's just not going to fly. It's just not going to fly.
So the point is, don't be too greedy.
Do not be greedy.
Yeah, in your restrictive covenants, you really need to be reasonable. If they're unreasonable, courts are going to have a hard time enforcing them. If they're reasonable, they fit your business, they fit what the employee does, you're going to have a much better, you're going to have the skids greased.
That's right. The next thing you can do in terms of your restraint is going to come with your customers, and we don't have it on there, but your employees as well. So in these restrictive covenants, you are permitted to, for a certain period of time, again, probably that 1 to 2 year period, you can say you're not allowed to have contact with employee or with customers that you worked with or that the business was working with during your time. You can also have that in terms of the employees that work at the business. You can't leave here and then solicit another employee to come work at your new competing business. But it can't be unlimited. So just because someone is a prospective, everyone's a prospective customer when you really think about it. You can't have in a restrictive covenant that an employee is not allowed to solicit any customer ever for their new competing, or for their business. That's probably not going to fly. But if it's someone that your business has specifically targeted, or if it's someone that is about to be in business, you know, if you're sort of in that stage where you haven't exactly come to terms, but you're in discussions, or if it's someone that employee has worked with specifically, you can have a restraint on them going after those customers. And similarly with employees, if somebody worked for your business 10 years ago, you can't prevent an employee within the restrictive covenant from going after an employee that used to work 10 years ago for your business. So there does have to be some restraint on that.
Yeah. So what do we mean here by a reasonable restraint on scope or activity?
So what we mean is, not all non-competes are going to work, depending on what the employee is going to leave and do for a competing business. And so what we mean by that is, if you work in, trying to think of a good hypothetical, but
Use the sales accountant one that we talked about.
yeah, if you work in sales, okay, and you are out there generating business for your employer, you decide you want to leave and go to work for a company that no question would be in competition with that sales business. But you go to work in, we'll say, a financial function. So you decide you want to change it up. You're going to work as an auditor.
Burn out with sales.
You're burned out with sales.
do
You've
it
had
anymore.
enough. You're going to go work as an auditor for a new competing business. That non-compete is probably not going to be effective in preventing that employee from going to, yes, a competitor, but in a completely different role than they had been with your business. So that's what we're talking about in scope and activity.
Great. So now you know the three main reasonable restraints. And you've heard us keep talking about different state laws, and we want to zero in on that right now for a moment. So restrictive covenants are an animal of each state's law. So contracts are governed by state law, and we have probably researched almost all 50 states over the course of the time I've been at Dickinson. I've either done it or reviewed research of associates. And I can tell you there is such a wide variety in state law. It is crazy, and it's getting even crazier. So if you have employees who work out of state for you, those employees, you can't use the same agreement likely that you're using in Iowa. There's probably 4 or maybe 5 states out there where we could use the same Iowa agreement, but every other state, you're probably going to need to have a slightly different, or in some cases, extremely different agreement. And sometimes you're not going to be able to put, you know, your sales force that's distributed around the nation, they're not all going to have the same restrictions because the different states that they live and work in are not going to allow for it. So it really is something where you can't have one template or one master that you just use for everybody. I know that would be great, right? It'd be administratively fabulous, and you'd know exactly what everyone's restrictions were, but that's not how it works.
Jill, just to put you on the spot, would our Iowa agreement work next door in Nebraska?
Absolutely not.
How about Illinois?
No,
Minnesota?
absolutely not.
Missouri?
I can't remember.
Am I forgetting any? I think I'm forgetting Wisconsin and South Dakota.
Kansas, South Dakota, I can't remember on those.
Okay.
Tiffany says we have a question.
We do have a question, and it is, if my former employer's business is purchased, does an existing restrictive covenant remain in effect relative to the new entity?
I think it's likely. It depends on the nature of the purchase.
Yep. And the nature of the agreement. Most of the agreements we write say that they are automatically assignable to a new business, and oftentimes the new business wants that protection. That's part of what they're buying, right? But even if your agreement doesn't say it, if the purchase agreement assigns them over, then it will be assignable over. Excellent question.
Yep.
Thanks, Tiff. I know it wasn't your question, but whatever. So the next place where you have to worry about state law is when you have employees working remotely, whether that's from home or on vacation or whatever. If you have employees doing that, state laws tend to start creeping in. So I know that that can be intermittent and that can be temporary. And we can't constantly be changing their agreements based on, you know, where they're having vacation for 2 weeks or something. But we do need to pay attention to that, and the pandemic has really put a spotlight on this.
Right.
And Rachel's going to talk about this later today, about some of the restrictive covenant things, or not restrictive, remote work things that have kind of come from the pandemic and are flowing over and going to be with us for a long period of time. The last thing I want you to be aware of is employees who move. So employees do tend to move because a spouse moves, or they move for a family reason, and they're going to leave their job, and you say, wait a minute, I think you can do your job remotely, continue to work for me. Remember that those restrictive covenants that you maybe have in place with those employees probably need to be looked at and reviewed, and maybe completely redone if they move out of state, or if you move them around to a different location. I've also had sales employees with a territory where they just had to live within or close to the territory, and they've moved around during the time that they've worked for the employer, and we have to keep changing their agreement every time they move around. So it's sort of a pain, but just understand that it happens, and we've got to deal with the state law issues.
We have one of our words, so you can mark that down.
What is the word? Say it.
Cowbell.
I want more.
You do want, everyone wants more cowbell.
Okay, all right. So Brian, tell me, what are we seeing at the law firm? What are we seeing in this last year or two?
So I think you talked about or alluded to it when we first started, which is we're seeing more people using restrictive covenants.
Yes.
There's an increased use, and part of that is tied to the scramble to get employees in the door. I think a lot of our clients are seeing what everybody is seeing across the country, which is the labor market. It's really tough to recruit employees right now. And restrictive covenants are one way that if a business has an employee to lock them in, and what I mean by lock them in is it's going to disincentivize that employee from leaving to go to work for a competitor. So that's one of the things we're seeing is increased use. Another thing where we're seeing is, I guess in terms of the quality of the agreements, we do have some clients that, or if a client will come to us and say, hey, we're going to hire this employee, here's a copy of their agreement from a prior employer, what do you think? And I guess what we're seeing a little bit is sort of agreements that have been worn out a little bit and have been used maybe a little bit too long and need to be updated.
You're being so nice.
I'm trying to be very nice. So
It's just bad agreements, all right? It's just, they're crappy.
we're seeing bad agreements. And I will say one thing though, just because there's a bad agreement doesn't mean that it's not enforceable.
That is true.
There can be very poorly written agreements that are still going to be enforceable at law. So one thing to keep in mind, we're seeing a lot more cease and desist letters threatening lawsuits against employees when they leave.
And we're writing
and
more.
we're writing more. It's
Yeah.
not just that our clients are seeing them, it's that we're being asked to do that. And there's a reason. I mean, obviously, if you're an employee, you've left your company, you're going to work for a new employer, you get this letter on law firm letterhead saying, hey, by the way, remember that agreement that you signed 10 years ago, which you may not remember at all, although I know we're going to talk about reminding people.
Yeah.
You may not have been reminded about that at all, and all of a sudden you're being told, hey, I can't go to work for that. It can be startling. Sometimes it's just done as a matter of course. Here's this letter from a law firm, hey, this is the reminder, you can't do this, 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 and this. And a lot of times, some of our clients might not even know whether that employee is in violation. It's truly a reminder. This is what you need to keep in mind. So we're seeing a lot more of that. Again, with the tight labor market, this is where the restrictive covenants haven't, clients that have a restrictive covenant in place have an advantage.
People are moving, so you got to remind them of these restrictions.
You gotta remind them of that, and again, tied to reasons people are moving. The vaccine mandates, I know just this morning, I think we've kind of laughed about this for the last few weeks, that we were joking that we knew that the morning of the seminar, I'll bet you OSHA was going to come out with the emergency temporary standard, and sure enough, this morning they did. But I think what some of our clients are seeing is if there's a vaccine mandate in place, some employees don't, for whatever reasons that they may have particular to their situation, they don't want to get that vaccine. So they're leaving to go to perhaps a smaller business. I know the OSHA ETS applies to employers with 100 or more employees. So they may be going to a smaller competitor where that might not be in place, or just where it might not be in place regardless. So those are some of the things that we're seeing.
Absolutely. So let's talk a little bit about litigation. So when we have clients who want to litigate, or when we have clients who get dragged into litigation, whether you're the losing employer, the employer who's losing the employer who's hiring the employee, there are various kinds of legal claims that can be brought. And we just put them together in a chart here for you. I don't want to get into much depth in these things, but what I want you to see from the chart is that it isn't just the former employee that can get sued. It is the new company hiring that employee that can also get sued. And most of the claims we can bring against both sides depending on the facts and circumstances of the case. That breach of contract, breach of the restrictive covenant, is the one we can only bring against the employee, and also breach of fiduciary duty in some cases. The rest of the claims we can bring against both the new employers. So even if you don't have restrictive covenants for your employees, you might be hiring employees who have them from somewhere else. So you do need to be aware of what's going on here. And speaking of that, on top of lawsuits, we can also get regulators
involved. This is going to be, I guess, this is a little bit fact specific depending on the nature of your business. I think the notifying the regulators, what we've seen with some of our banking clients, is that the Fed has gotten involved if there has been, certainly if there's an egregious breach of a non-compete, non-solicit, or trade secret, but it might not even go to that level. There was a case very recently out of, I think it was Wyoming, where there were two employees of a bank. They made an agreement during their employment they were going to leave, they were going to take customers. One of them did leave. One of them left, one of them stayed. While that still was going on, they were conspiring with each other to try and get customers over to what was going to be both of their new employers. Ultimately, their former employer sued them, got a $2 million judgment. Not that wasn't bad enough. The Fed then stepped in and wanted to and did prevent them, after an ALJ made a decision, from working within the financial institution realm. So it's not just you as the employer that you need to watch out for. It's also some of those outside regulators.
All right, next slide is the next secret word, drums. So this is the session that had the two words in it. And that is Jill in 1975 or 76 playing the trap set there for jazz band. Woohoo!
Very John Bonham.
Oh, yes.
Yep.
All right. So Executive Order 14036 was issued by President Biden on July 9th. And he really is just trying to tighten up anti-competitive measures in the United States. And he's kind of directing different agencies to tighten things up. And one of the things he wants to do is the FTC, Federal Trade Commission, issued in October of 2016 an antitrust guidance for HR professionals. And we've talked about that before at our seminars. And he wants that tightened up. And he really does not want restrictive covenants with lower wage earners. So that's something that's coming at us, I think, sometime during the Biden administration, but we haven't seen it quite yet. So we need to rush through these tips really super fast. Brian, do you think you can do it?
I think we can do it.
The top 5 are tips for if you are the employer who is having restrictive covenants with your employees and you're the former employer, what our tips are for you. The bottom 5 tips are tips for employers hiring employees who might have restrictive covenants. So I'm going to start. Number 1, include restrictive covenants with your job offers. Not only mention them, but have the document and give it to the employee in advance, letting them know what the restrictions are. 2,
get signed agreements from your employees prior to their start. If you send out with the offer letter a restrictive covenant, don't let that employee start until you get it signed and returned back. We've had a couple clients that have reached out to us that wanted to bring action for an employee leaving, and they couldn't because they didn't get the signed restrictive covenant back.
Right, and the same if you give a new restrictive covenant to a current employee, make sure you get the signed agreement back from them. Can't enforce it without a signature.
Cannot.
Number 3, when people leave you, remind them of their obligations. Give them a copy of that agreement on their way out the door or when they give you their notice.
Number 4, check activity of the people that are departing. And what we mean by that is, I know we're running a little behind here, but if you have a situation, particularly if you have an employee where there's a departure that's unexpected and immediate, you want to take a look at perhaps the emails that that employee has been sending immediately prior to the departure to see if anything was sent out the door into their own personal accounts.
Right. Number 5, send cease and desist letters when you identify wrongdoing or you want to remind somebody because you forgot to remind them on the way out the door. Now we're switching over to the new employer. So
if you're hiring an employee, you should be asking them about whether they have any restrictive covenants in place. And if they do, you need to ask them for a copy of that. Now, Jill and I were talking before we started this, the vast majority of restrictive covenants that I've seen are not confidential in nature. In fact, I want my departing employees to show those restrictive covenants to their new employers so they know what's in place. So you need to be asking those employees, those new hires, about whether they have anything.
Number 7, do not review trade secrets information or confidential information a new hire brings to you or in the applicant process. I have had clients who people bring in client lists during their interview to try to, push over the edge and get hired. Don't look at them. That's other people's trade secret information. Thanks, don't want to look at it. Don't bring it in.
Number 8, do not ignore a cease and desist letter if you get it. Please do not ignore a cease and desist letter. There should be either us as your attorneys or some in-house counsel if you have it. Someone should be responding to those with something even more, likely more than just we got it. But I had a client situation where there were several cease and desist letters sent. Those were ignored and ultimately resulted in litigation. So you want to make sure that you are responding. There's nothing people hate more than being ignored.
You just took the words right out of my mouth. Number 9, do not share legal opinions. So you may get new hires who come in and say, oh, I had this run by my attorney and it's just fine, it's not enforceable. Or recruiters who say, oh, we looked at that and our attorneys looked at it, it's not enforceable. Do not rely on anybody else's legal opinion. You get your own. Everybody has their own interests in this game. You have to get your own legal opinions. And don't be sharing them with other people. You're waiving your attorney-client privilege when you do that. Get your own opinion, keep it to yourself.
Last one, monitor activities of your new hires. So we just went through all the things you should be doing with those new hires. Even if you feel good about the restrictive covenant that they have in place and that they're not violating it, you need to be making sure that they're actually not in violation. Jill showed you that checklist of everything that not just the employee can be sued for, but the new employer can be sued for as well. If you are aware of an employee that has a restrictive covenant in place, and then all of a sudden they're soliciting against that restrictive covenant people, former customers that they shouldn't be, you and your business can be liable as well. So you need to make sure you're monitoring.
We just did double time. That's what you call it.
Double time.
In music, it's a
Double
double time. Okay. So next up is David Gonzalez. Are we going to take a quick little break to switch him out? So just a couple of minutes, and we'll be back with David Gonzalez. Thank you.
Welcome back again from our quick change. I'm David Gonzalez, and I get to talk about world music, some updates from the immigration world for employers. And some of you that were part of our seminar last year remember right at the end of our seminar, I made what I think was the most low stakes prediction I could have possibly made in telling everybody that I did not think that there were going to be any changes in immigration law over the next year, no matter what had happened in the elections. And much to my shock, there was an attempt, but it didn't work out. So we are pretty much going along just as we were before. And I am going to give you guys my secret word right up front. And my word is overture. The picture that you see on your screen there, that's a depiction of what I consider my second favorite overture, the 1812 overture. The only reason I like that one so much is because it's got cannons in the sheet music. I'm a big fan of cannons, having been an artilleryman in the Army all those years ago. But what an overture really is just a little bit of a taste of what you're going to get for the full piece of music. So you'll get a sample of this and a sample of that and a sample of this that we're all going to then explore a little bit later in the piece. And that's really what I'm giving you. I'm giving you little bits and pieces of kind of what's going on in the immigration world that then if you have more questions, definitely you want to contact the law firm at Dickinson Law, and we'll be able to help you out to look into some of these deeper questions. Now, as far as the topics are concerned, 5 very, very quick ones. I'm going to talk briefly about Social Security Administration no-match letters and why they're important to you. Some changes and then changes back that have happened in the DACA program over the last year. Some changes in the asylum world and how that affects and touch on that. But I think what's probably more important for you as an employer is just to kind of have an idea of what temporary protective status is and know why these are people that can possibly work for you. And then finally, we're going to take a look at work authorizations, because so often I will get calls or the firm will get calls and someone will say, you know, we need this specific type of visa, and that really should be something that you have a much broader discussion about. And when we get to that part of this, we'll talk about why. So let's first start with Social Security Administration no-match letters. This was a practice that had gone on for quite some time. Employers would get notices from the Social Security Administration that said, the information that you have submitted for this employee, the Social Security number doesn't match the name that we have, and could you please investigate it for us? They were terminated way back under the Obama administration many years ago. During the Trump administration, they were brought back to life and we started to see them again. And as soon as the Biden administration took over, again, they have discontinued the practice. That is not to say that the practice will not restart again under whatever the next administration happens to be. And so it's just kind of a good idea for us to talk about what an employer needs to know about these type of letters if they do come back again. The good news, of course, right now is that you shouldn't be seeing them for a while. These letters, when they came to the employer, they basically requested assistance. Hey, can you help us to verify, is this number really for this name? And they were asking the employer to then provide that information to the employee. What was weird about them was that there was really no enforcement mechanism for these letters. The employer could ask the employee to, hey, could you please try to straighten this out with the Social Security Administration? And there was a failed rule at one time that would have created a presumption against employers that said that they were presumed to know that this was not an authorized employee for probably some pretty obvious reasons. That rule never was finalized and never went into effect. But it did cause a lot of trouble for employers. Sometimes these letters would come in and the employer would go to the employees and say, hey, we've got these letters. And sometimes, I would say even more often than not, some of the employees would simply walk off the job and we would never see them again. Now, what that meant, you can make your own conclusions from it, but it's definitely a problem for the employer. That rule is probably never going to be put into effect, but in the future, if we see these no-match letters return under the next administration, just something to keep in mind. Next, let's talk about DACA. DACA has come back once again, and we've had a few DACA matters come through our doors at the law firm so far this year. Back in January, right after inauguration, the administration fully reinstated DACA. Now, what did that mean? That meant that not only could people who had previously gotten deferred action able to renew that status, it's not an official status, but renew that work eligibility, renew that deferment, but also they were going to be taking new applications again, which had been stopped under the previous administration. Then in July, a court down in the Fifth Circuit decided that the action to reinstate that program was not done in compliance with the APA. And so they stopped the new applicants again. The people who currently have DACA are still able to apply for renewal, and they should continue to do that if you have some employees that are doing that. But that process can take time. Usually, an immigration attorney will recommend that somebody who has DACA is going to submit that application about 6 months before the end of their current deferred status, so that USCIS will have time to process the application and hopefully get their renewal to them. Now, if that processing doesn't happen fast enough, what you could end up with is one of your employees having a gap in their employment eligibility. That, if you run up against that, that's something that we have handled at the firm. Brian, who was just speaking, and I believe will speak here in a couple of minutes, and I have worked on that. There are some strategies that you can have so that hopefully you don't just completely lose that employee, but maybe they're just taking a leave of absence for a short period of time. So that's something to keep in mind when you're filling out that I-9, and that employment authorization document's got the end date where it's no longer valid. Want to make sure that you calendar those dates, keep track of it, and keep in touch with those DACA employees to make sure that they get that renewed and hopefully don't have to interrupt their work. All right, changes in the asylum process. This is one of the most talked about immigration processes out there, and during the previous administration, there was a program called the Migrant Protection Protocols. It was more commonly known as the Remain in Mexico program. These were people who had crossed the border and had applied for asylum and then were sent back to Mexico. That was, again, terminated at the beginning of the administration, but again, courts stepped in to say that they didn't terminate that program properly. So the MPP is still in effect, but the problem that has arisen now is that Mexico had to agree to hang on to these migrants who were coming north. Mexico, as of September 15th, when there was a court filing, we still don't have an agreement for anybody to go back. And so, you might ask, hey Dave, that's all great, but what does this have to do with me? Why do I care as an employer? Well, the reason that you care as an employer is that someone who has applied affirmatively for asylum status, for asylum in the United States, 6 months from their application will be granted work authorization. And they will get that work authorization through USCIS. It will go directly to them. And the asylum process is very, very long. It takes a long time. As a matter of fact, it is not uncommon to have 1.5 years or 2 years go by just for that initial application with USCIS. Something that's not very commonly known is if that application before USCIS fails, that does not mean deportation. It means referral to immigration court. And again, with the backup in immigration court, we're looking at probably another 1.5 to 2 years. All of that time, this is someone who's eligible to work. So these are also very tight-knit communities that once you tap into, you'd often be able to find, maybe not just one employee, but maybe multiple employees who are currently seeking asylum that have work authorization within the United States. Before I move on from asylum, though, I do want to point out one thing. An asylum application should not be done flippantly. There are unscrupulous individuals out there in the world, some commonly referred to as notario publico. These are people who assist people who have come to the United States and haven't gone through a port of entry, and what they do is they file basically an unreasonable application for asylum with the only goal of getting that work authorization. Often not even telling the applicant that they have applied for asylum. They're just they just have said that they're going to get them a work authorization, and that's all the questions that are asked. The problem becomes that these applicants for asylum effectively don't know about their proceedings and often end up sometimes with removal orders without their knowledge. It's the reason I brought it up today. I just had something like that hit my inbox this morning, and so it's something that it's not limited to just maybe in Texas or in Florida. It happens right here in Iowa, and so it's something that if you're connected to those communities, you'll want them to look out for. Temporary protected status. These are residents of certain countries that the United States has said that conditions in their country are so bad that we will not be returning them to their country. There's a handful of countries who are currently eligible for TPS, or residents of these countries who are in the United States. You do not have to have entered through a port of entry for this. Those are Myanmar, Burma, El Salvador, Haiti, Honduras, Nepal, Nicaragua, Somalia, Sudan, South Sudan, Syria, Venezuela, and Yemen. You'll recognize those names from in the news, either through natural disasters or because there's some kind of armed conflict. They do have work authorization. These people are allowed to work in the United States. The big Supreme Court case that came out in the last year does not have anything to do with their work authorization. What it does have to do with is that being on TPS does not provide a path to legal permanent resident status. So they will have to continually get that TPS renewed through USCIS. And like we've talked about with the DACA applicants early on, that process can take some time. And so they'll want to make sure that they're staying on top of it and that they always are a few months in advance so that they don't have that gap in work authorization. And so now that comes to kind of the last thing that we should talk about, and this is, who can I hire? Who out there as a migrant, as an immigrant, as someone who's visiting the United States, who am I allowed to hire? What are the visas that are available? Most often when a call comes in, I think we always, the first thing we come to is either it's the H visas. It's the H-1B for a specialty occupation, the H-2A for a seasonal ag worker, the H-2B for a seasonal worker that's not in agriculture. But there are a whole lot more visas out there than that. And when you call up and you're thinking about, we might want to hire a foreign worker, you want to have that conversation up front with the attorney to talk about which one is the most appropriate, for you. I listed on the slide, all of the temporary work eligibility visas, permanent work eligibility visas, which are a little bit different. Some student visas allow work. Some F1 students who are just, would be a university student. J1 visas, that is a medical student. But looking just for a second at the temporary work eligibility visas, they have their own special purposes, and most people are aware of the H-1A and the H-2, or the H-1B and the H-2A and H-2B. But you may be wanting to hire somebody who's got extraordinary ability, someone who is just head and shoulders above their field. And an O-1 visa might be more appropriate for them. If you happen to be, a church and you're hiring a foreign worker who is a preacher, perhaps, that's an R1 visa. So that's probably the more appropriate visa. And I think one of my favorite ones is the E3 visa, which is specifically for people who are coming from Australia. For whatever reason, we give some special treatment to some executives coming from Australia. So it's important to have that deeper conversation and know that when you first call your attorney up, you're going to know that you'll have some basic information. You're going to want to know, where is our candidate from? What are we going to be having them do? What are we thinking about paying them? Is this an executive level? All of these things are important to the conversation, and we want to have a deeper conversation because in some cases there may be an easier path than that H-1B where we're talking about a lottery, where there's nothing guaranteed as far as getting that work eligibility. So that's your overture, bits and pieces of what's going on in the immigration world for employers. If you have any questions, if you want to have that deeper conversation about what visa is most appropriate, always happy to talk to you guys. My email address and phone number right there on the screen. I try to answer my own phone as much as I can, so I'm always happy to talk, so feel free. And I think, Jill, we're going to go to break now, is that right?
We are going to break. Thank you so much, David. Always enlightening on immigration. And we have break until 1:45, so we will see you in a few. everybody. Look who's with me again. I can't shake you.
Hi again, Jill.
Hi, Brian.
We're getting the band back together.
We're getting the band back together again. And this time we are going to read the sheet music with you to evaluate and improve documentation. So this is a rolling scenario that Brian and I have put together of verses of a song. So think of it as band or chorus practice here. And we're going to talk about documentation really broadly today. Not just the documentation that you or your supervisors write up and put together, but also documentation you receive from other people like medical providers or employees, and you have to evaluate that documentation to make a decision. Our scenario is going to involve work comp, FMLA, ADA, even extended EPSL, and a request for reasonable accommodations for religious conflicts with the COVID-19 vaccine. Now, we may not get to every piece of these. We definitely want to get to the last one. So if we skip a verse or two and there's a little skip in our record, it's going to be okay. You're not going to miss out on anything. We do want to get to the last one. So here we go with verse number 1. So I'm going to set up the scenario for you guys. We are going to be dealing with Jane Smith throughout our session here. And Jane is at a rural community factory of 200 employees. And she installs small parts onto large farm equipment. So think combines and big sprayers and that kind of stuff. And so she has to be up on ladders to install these small pieces on top of it. She has to be on creepers to lay down and be underneath it. So, top to bottom, she's installing these parts. She has worked for this employer for 10 years, and she has a history of many workers' compensation injuries. Jane is a little bit clumsy. Yeah, that'd be a way to put it. So Jane's most recent injury is that she fell off a ladder on the first day back to work of this year, January 4th of 2021, right after her shift began at 6 o'clock in the morning. So the safety director did the right thing, filed the first report of injury, and sent her off to the company doctor to be evaluated and treated. She comes back a little while later, around 10:30, and she gives her supervisor this doctor's note. And it says, all right, Jane Smith, seen today 1/4, released to return to work immediately with these restrictions. Light duty as tolerated until cleared by the orthopedic team. So Jane has injured her back, neck, kind of, upper torso type stuff. So Brian, you tell me, do you think this documentation that you got from the company doctor is sufficient for you, the employer, to know what to do next?
No, it is not. It is objectively insufficient to allow us to know what she can and cannot do. So let's take a look at what the doctor is saying here. It says light duty as tolerated. Well, how do we know what as tolerated means? As tolerated for a more stationary desk type job can be completely different than you would maybe have in her type of position where she's up on ladders and working repeatedly. So we need more information now. Sometimes it can be uncomfortable and employers feel like they can't ask additional information, but with situations like this, you absolutely need to ask additional information to know what you can and cannot do, or more to the point, what Jane can or cannot do. Right. So what we need to be doing is asking for that additional information and not allowing her to work until we get that additional information, because the worst case scenario would be for us to have a different interpretation of what light duty is than what her doctor does, and we put her back to work to do something that's going to actually hurt her more than she would have been if we had a better understanding of what light duty meant.
I think too many employers just accept light duty, like everybody knows what light duty is. Well, I don't know what light duty is. Light duty can be a bunch of different things.
Lots of things.
And we can't determine what it can be unless we know what they can and can't do. Now, doctors are going to push back. They don't want to, this is easy, light duty. They don't have to explain what the employee can't do. But in this particular case, this is a work comp doctor, right? It's your own doctor. So you should be able to push back on the doctor to get more information, right? So in a perfect world, that's what you would do. The other thing to know about this kind of documentation is that Jane turned this into her supervisor. Now, what do you think of that, Brian?
I think that's the appropriate place for Jane to have turned it into, but Jane also, or excuse me, Jane's supervisor then needs to place that into the hands of someone better suited than the supervisor. So the safety director or someone from human resources. It should not be staying with the supervisor. And the supervisor the safety director, HR, everyone involved needs to understand that this document right here from her medical provider is a confidential medical record and should be treated as such.
Absolutely, absolutely. So in a perfect world, you would push back, get more information, but it's not a perfect world, and we all know that. So verse 2, Brian.
Verse 2, so Jane, her supervisor lets Jane know the return to work is going to, the supervisor let Jane return to work on January 4th without notifying safety or HR.
Uh-oh.
Yeah, that's not great. Jane sorted nuts, bolts, and washers, which is typical light duty in this department. And Jane could sit or stand as she wished. At 2 o'clock on January 4th, Jane said she could not work anymore due to back and neck pain. Jane was sent to the safety director, who sent her back to the same doctor. So, Jill, I ask you this. Is there after reviewing this county medical center information from the doctor, which says additional information that she is off work until evaluation by the orthopedic surgeon on Friday, January 29th. So we're looking at almost 4 weeks, a little less than 4 weeks later. Reevaluate after that. Jill, is this sufficient documentation, or is there anything additional that we need?
Surprisingly, you need additional documentation. So, you know, Jane comes back later that afternoon, and, you know, your own work comp doctor kind of says, fine, you want to know what light duty is? I don't know what it is. Just take her off of work.
Just take her off of work.
Just take her off of work. Great. You get what you asked for, right? So, or, you know, she comes back and says, oh, I hurt too bad. And he's like, fine. You just don't work until the orthopedic surgeon sees you. Fine. You just don't stop there, because guess what? Workers' comp and FMLA can run concurrently. And we know that this employer has 200 employees, so they're a covered employer. And she worked for them for 10 years. So as long as she worked 1,250 hours in the previous 12 months, which she had a lot of injuries, we don't know, but we're going to assume she did, FMLA is going to apply here. And you should be running FMLA concurrently with that work comp leave. All right, so the documentation you're missing is FMLA Notice of Rights and Responsibilities. Now, you do not have to send a med cert along with this, because you can use the information you get from your work comp doctor to substitute for the med cert. So no need to send the med cert, and you can send the designation notice right away approving the FMLA, because you know, based on this note, it's qualifying and it's work comp and it's going to make it. So just send the notice and also send the designation of FMLA right away. All right.
Verse 3.
Verse 3. Oh, that's my verse. Okay. Take it, Jill. All right, Jane, here's what happens to Jane next. Her appointment with the orthopedic surgeon, which you saw took about a month to get in the first place, gets rescheduled due to the doctor's scheduling conflicts. So she gets to wait yet another month for the next appointment. As luck would have it, the day before that rescheduled appointment, she has a heart episode where she has to go to the emergency room, and she cannot go to the appointment the next day because she's recovering from her heart episode. So now we get to reschedule the orthopedic surgeon appointment a second time, which takes yet another month. So Jane is going to be out until the 29th of March. So I ask you, Brian, first of all, how about that first month of delay where the doctor couldn't get her in? Does she still get to stay on work comp?
I think the answer is probably yes, she does. It's something you're going to want to work out with your work comp carrier, but taking the conservative approach, this is something that was not due to Jane's inaction. It's not something that anyone could likely help except for the doctor. So I think in this situation, we're probably going to allow that.
Okay. What about the second incident where we have another month of delay because of Jane's own heart episode? Does her own heart episode come in and say, oh, you're off work comp now and you should be on some other kind of maybe FMLA leave for your heart?
Again, you're going to want to talk with your work comp carrier here, but I'm going to default to the conservative position and say that, yeah, I think we probably continue with her on work comp.
And FMLA?
And FMLA, absolutely FMLA. She's got a serious health condition that's going to apply here. So I think we probably keep her off for both.
Okay, I agree. Verse 4 is yours.
Verse 4.
Take it.
Can you advance
Oh,
that?
yeah.
Verse 4, Jane
Sorry.
sees the orthopedic surgeon on March 29th, 2021. So this is almost 3 months after the initial injury, almost.
Finally.
Finally, the work comp nurse assigned to the case attended the appointment, and the nurse sends a doctor's note to the employer after the appointment, and the doctor's note says, It's a little more specific this time. It says no repetitive lifting, pulling, pushing, bending, stooping, or squatting. Avoid lifting over 10 pounds. Physical therapy 3 times a week. Spinal injection on March 9th. So, Jill, is there any further documentation we need right now?
Probably not. This doctor's got it going on. I mean,
This is someone that has seen this type of injury before.
exactly. The only thing that's a little bit, I think, vague is repetitive. What does repetitive mean? But I think there's enough restrictions in there that pretty much, I don't know what she could do.
And with a work comp doctor, this is the type of note that you're more likely to see from the company's work comp
Right.
doctor, especially the language about repetitive.
Yep.
No stooping, no bending, no squatting, no pushing.
Totally, totally. I agree. So the question is, what do you do with this? Well, the first thing you got to do is figure out what Jane can do within these restrictions. So we're going to take her current job description, which is her parts installer description, and here it is. And this is the list of her essential job functions. So she's supposed to be efficient in installing tools, she's supposed to prepare them, and she has to move them around, pallet jacks, forklifts, you name it. She has to open up boxes and stuff. She has to maintain an orderly and clean part storage area. She's got to keep her hand tools and her ladders and other kinds of equipment she uses in good working order and clean and maintained. She's got to work with the safety director, which basically means follow all of our safety protocols for the different equipment that you're using. She has to inspect her own work, and if she sees something wrong, she's got to fix it, and she's got to complete some paperwork once the job is done. And then if she has to reinstall anything, maybe quality assurance comes up to her and says, hey, this wasn't done right, or somebody needs to fix this and redo it. She's got to do that. And she has to maintain this weekly schedule and other duties as assigned. So, Brian, I ask you, does this job description adequately describe Jane's duties so that you can take this previous orthopedic surgery doctor restrictions and say what Jane can and can't do in her current job?
No, it doesn't. What this does is it describes what Jane's job is, but it lists everything as an essential function. If you'll look at the second bullet point, for instance, one of their essential job functions is that she has to maintain a weekly schedule. Well, every employee has to maintain a weekly schedule. It's not likely that that's going to be an essential job function. So when you're crafting your job descriptions, you want to make sure that you're actually describing what is essential to the work that you want this employee to perform. Is it going to be for her type of job? Is it going to be lifting heavy equipment? Is it going to be fixing particular things? You want to be specific with these because for the essential functions, you have to provide an accommodation, a reasonable accommodation to allow this employee to perform those essential functions. If they can't, then you can't provide the accommodation, but you can't just describe everything as essential. That doesn't work.
Right. And you see the disconnect here between what the doctor is saying she can't do and what the job description is. I can't, none of those words are used in here, the squatting, the lifting. I don't even know what the lifting is. So none of that stuff is here in the essential functions of the job description. So we've got to look elsewhere. Maybe we'll find it further in the job description under the skills, the knowledge, skills, and abilities.
Well, let's take a look. So under knowledge, skills, and ability, we see excellent knowledge of farm equipment and how to use hand tools to install parts. That's a little bit more helpful. Ability to crawl into tight spots, that's a bit more helpful. Able to climb ladders and work extensively at heights. Ability to read, understand, and follow technical documents in order to install parts, also beneficial. Understand and follow safety precautions, and trained in forklift operations. Does that do anything for you, Jill?
It's helpful, but you know what? All of the things that the orthopedic surgeon said she couldn't do, none of them are listed here. So I don't know how much of her job involves stooping or squatting or how much the lifting is and all those things that he said she couldn't do.
How much can you infer from the no stooping and reading something where it says ability to crawl into tight spots? Can you infer any?
Maybe you could infer some. I would say it's possible that you could infer some, but you know, I would like it to be a little bit more specific, because if you put the two of them together, it actually is like, well, I'm not sure, maybe she could do her job. Maybe these restrictions aren't really restrictive enough for her. So if you don't have it in the job duties, you should include it in the qualities. The best job descriptions I've seen, particularly for manual laborers, blue-collar workers, includes like how frequently they have to lift and how heavy they have to lift, and whether it's from ground to waist or waist and above the head. The more specific you can get with that, and I have found voc rehab counselors are great at this. They can watch people do the job, time how much they do it, you know, whether it's frequent, occasional. They've got all these terms that they can use. Those are the best job descriptions. So if you have that kind of a workforce and those kinds of jobs, I recommend you get really specific in your job descriptions if possible. All right, let's move on to verse 5, which is my verse. Okay, so next, there is now a significant slowdown in installing parts due to supply chain disruptions. All right, big thing happening to everybody. There is no light duty work available for anybody because they have been trying to keep people busy, and so all of the nuts and bolts and washers are all sorted. And they've even been rotating employees from the parts installation department into the paint department to learn jobs there, cross-train, keep people busy, cover for absences, whatever. We're trying to avoid furloughs, RIFs, job eliminations, whatever. And we've even put a hiring freeze into place. So, Brian, what now? All of this is happening at the same time that Jane brings us this orthopedic surgeon note that says what she can't do.
Well, we don't have any obligation to create a position out of thin air, but what we should be doing is taking a look at for our parts installers that are rotating into the paint department to learn some of those responsibilities. We need to take a look at Jane's restrictions and see, is this something that would be within her restrictions? So can we rotate her into a position like that without violating those restrictions?
Yep, good idea. So we've got to look at other vacant jobs in the plant, or if we're rotating people among jobs, we're going to have to look at every job we're rotating, right?
That's right.
Okay, very good. Verse 6, it's
Verse
yours.
6. So, while the company has been trying to determine whether they can accommodate Jane's restrictions, her husband became symptomatic and tested positive for COVID on April 1st of 21.
When it rains, it pours with old Jane here.
That's right. Jane's had a rough run of it, I'll tell you what. Jane, she's got to quarantine for 14 days per CDC guidelines at the time and company policy, and her husband gets worse and is hospitalized on April 9th. Jane requests FMLA to care for him. Jill, how should Jane's time off be treated, and how should it be documented?
Well, here's the first thing. We haven't determined whether we can bring Jane back to work at all yet. So if we can't accommodate her restrictions and there's no work we can have her do, we would probably continue her on work comp leave and her own FMLA leave. That's going to kind of be the priority leave. But if we've been able to bring Jane back to do some light duty, we actually won't bring her back because she will be out on a new FMLA to care for her husband. So if that's the case, if we think we could have brought her back, but she can't come back because of her husband, now we issue her new FMLA papers for her husband. So that's a new notice of rights and responsibilities with the med cert for the family member. And then once you get that back and look at that, you'll probably be issuing the designation notice to approve that leave. And once the husband is okay, she's not needed to care for him anymore, then hopefully she can come back to whatever this accommodation or light duty work might be.
Boy, I sure hope nothing else bad happens to Jane.
I do too. Oh wait, we're going to take a little intermission. Here's our secret word. Guitar is our secret word of the day for me. That is me sitting there playing the guitar in bare feet. It is during a swing choir concert in 1977, and I am singing my own song that I wrote called Mixed Emotions. And you probably have mixed emotions about Jane right now if you were her employer, or you might have mixed emotions about your chosen profession and wonder, why did I get into this HR stuff? But moving on.
This is not me, but this is the next word, and it is jazz flute.
Oh my God, who is that?
Who could it possibly be?
Will Ferrell.
It's Ron Burgundy. It's Ron Burgundy.
Oh, there you go. Yeah, more cowbell.
That's right.
All right, so verse 7. We've gotten to verse 7. So here's where it gets interesting with vaccine mandates. All right, Jane has taken all of her FMLA and then some with all this time off for herself and her work comp and her husband, and she's finally able to return to work on July 5th of 2021, right after the 4th of July. Her back and neck pain are largely resolved with the help of that injection she got, the physical therapy she went through, and probably the 6 months of ending up not working at all.
Probably helped.
Yeah, that probably helped. So now she is actually medically released to return to work with no restrictions. Hallelujah.
Yeah.
Right? Okay. So on 8/2, a little less than a month later, the company announces that it is going to institute a mandatory COVID vaccine policy. And everyone must be vaccinated by October 15th of 2021. And Jane says, I do not want to get the vaccine because it conflicts with my religious beliefs. What documentation do you get now, Brian?
Well, when you hear I need an accommodation or it conflicts with religious beliefs or disability, any of those code words, immediately you're thinking, as an employer, you should be thinking, and this employer should be thinking, got to begin the interactive process to determine if we can provide a reasonable accommodation for Jane due to her religious beliefs. And I think this is something that if you haven't seen it yet, there's a very good chance with the new OSHA regs, which just came out this morning, with the contractor rule, with the CMS stuff, you're likely going to be seeing or have some employees that are going to be requesting religious accommodations based on the mandatory COVID vaccination policy.
Absolutely. And we're here to help them.
Of course we are. So we have developed a form for employers to provide to employees, depending on the type of situation, if they're requesting an accommodation from the COVID vaccination, mandatory COVID vaccination based on disability, or like Jane here, whether she's requesting it due to a sincerely held religious belief.
We released those forms out to our clients for potential purchase for $25 a few weeks ago. And tomorrow we will send all of you who attended an invitation to purchase them if you would like yourselves. If you are not a client of the firm, they will cost you $40 to get the 2 forms. If you're a client, you can get them for $25. And we're going to give you a little sneak peek into the religious form here in this process. So we have, Brian, the first excerpt from the religious accommodation form, which is, do you have a religion or not?
Do you have? I mean, pretty simple. We need to know the basics right up front. So it's asking Jane to attest whether she has a religion. Is your religious belief system part of a traditional organized religion? Yes. And what is the name or sect of that? And she's listed Christian Assemblies of God. The final question on this particular form is, do your beliefs differ from the tenets or principles from the religious belief system described in 1A? Which is, and she says no. So, is Jane's belief a religion, Jill?
I think definitely so. So part of this form, the last page of this form has definitions that we took from EEOC guidance and EEOC regulations. And we put some definitions in there for what a religion is and isn't. And the first thing that definitely is a religion is traditional organized belief systems such as Christianity, Judaism, Buddhism, Hinduism, etc. So Jane says she's a Christian. She's definitely in there. She tells us her specific sect is the Assemblies of God and that her beliefs follow right along with that of the Assemblies of God churches. So we can actually go out to the Assemblies of God churches on their website and try to find out, okay, what is their belief around the COVID-19 vaccine to see if that lines up with what Jane tells us later in the form is her belief. But here she has passed the first hurdle. She definitely qualifies as having a religious belief. So the next question we have to ask, and you're not seeing the entire form here, you're seeing pieces of it. The next is, how sincerely held is this belief? So that's another piece we have to find out, right?
Right, so these questions are trying to get to that. So she's asked, when did you adopt the religion beliefs described in your answer? And she says, raised Christian Lutheran. The fourth, explain the circumstances under which you adopted the religious beliefs described in your answer to question 1. And she states that I accepted Jesus into my heart in 1990. A friend invited me to First Assembly of God Church. The fifth question is, do the beliefs described in your answer to number 1 apply to all vaccinations? She says no. And in their explanation portion, she says not all vaccines have aborted fetal cells. So Jill, what do we do here?
The question is whether what Jane told you here indicates that her belief is really sincere. And I think it does, but there's a hitch to it. So she says She was raised in Christianity, she's accepted Jesus, and she attends a church, and this has been going on for quite a period of time. So one of the definitions we have at the end of our form is what is sincerely held, and what are the factors the employer can consider for sincerely held. And they include, is your belief consistent or inconsistent about the vaccine? Is that consistent with your professed beliefs? Have you requested this accommodation because it's particularly desirable? Is the timing of your request suspect? Is there any other reason for us to believe that you might be kind of faking it here? So that's where the little hitch comes in here, because she says that her beliefs described do not apply to all vaccinations. They apply only to the COVID-19 vaccination, and that's because of aborted fetal cells. Now, first of all, she says not all vaccinations have aborted fetal cells, so I don't know what she means by that. Does she think aborted fetal cells are in the vaccination? It's my understanding that they were used in the development and testing of the vaccination, but they're not actually in the vaccination that's injected. So I'm not quite sure. Maybe she doesn't really quite have correct information. So perhaps one of the things I would do here is to provide Jane with some educational information about the vaccine, what's in the vaccine, what was used for the testing. I do think it is true that fetal cells were used for the testing of all 3 vaccines, and there is the possibility and likelihood that aborted fetal cells were used. So if that conflicts with her belief, I think we've got some sincerity here. The problem is that virtually every modern vaccine has been developed and tested using fetal cells, including aborted fetal cells. So the fact that Jane only has a problem with the COVID-19 belief, indicates some problems with sincerity. So again, maybe some education to Jane about these other vaccines and how they were developed. Now, this is something you want to get from your company doctors. You don't want to be playing doctor. You and I went to law school, we've got law degrees, we don't have medical
We are not
degrees.
doctors.
We are not doctors. All right, so we're gonna say, for the sake of argument here, that we gave Jane the extra documentation. She's still holding steadfast. We're gonna accept it as sincere because sometimes getting into these too much deeper is a little dicey. So now we're gonna move on to, okay, what is your conflict between the vaccine and our policy?
And what she says is, the vaccines have aborted fetal cells, which goes against my belief. I believe life begins at conception and abortion is an act of murder. Proverbs 6:16 informs that one of the things God hates are hands that shed innocent blood. So the next question she's asked, if requested, can you provide documentation or other authority to support your explanation of your religious belief and how it conflicts with the COVID-19 vaccination? And she checks yes. So what is, again, with this fetal cell issue, what do you make of this, Jill?
This clearly shows a conflict between her beliefs and the policy at the employer. So there's no doubt there's a conflict there. And she says she can give you an attestation from her faith leader. And if you're unable to verify via internet searches that the faith belief lines up with her belief, it would be a good idea to ask for that statement from the faith leader to support it. All right, last piece is, what kind of accommodation could we actually make? What is she asking for? So on the form that we actually have some check boxes because this is a form specific to COVID-19. I have not provided all of the check boxes here, but I provided you with the 3 that Jane checks. And she said, hey, look, I will test weekly, I will wear a face covering when I'm on the premises, and I'll keep 6 feet of distance, and I'd like to be completely exempted from the vaccination requirement. And that's the only thing I'm declining. I'll do everything else that you ask of me. So, the question is, do we think we can accommodate that with Jane?
And the answer with this one is probably yes. And again, it's going to depend on what your employees are checking. If we can go back to this real quick. So again, here she's checked that she's willing to have a negative COVID test on a weekly basis, that she's willing to wear a face covering on company premises, and that she's willing to maintain a 6 feet distance from other people. Those are all potential reasonable accommodations that she could get, or we could provide to her for her religious beliefs.
The key here to me is that we don't just exempt her from the vaccine policy and then not do anything else. We need to provide some other accommodations around that to make sure we're keeping her safe, her coworkers safe, patients, customers, et cetera, safe.
If she doesn't check any of these on here, if she says, I'm not willing to get a negative test, I'm not willing to wear a face covering, I'm not willing to maintain 6 feet of distance, this is probably something that we're not going to be able to accommodate for her, because it comes down to whether it's going to be an undue burden for the employer. And you as the employer, it's got to be basically just a minimal burden to you, and you don't have to provide that. And with her saying, again, hypothetically, if she were to say, not going to do the testing, not going to wear the face covering, not going to maintain the 6 feet, then that's probably an undue burden for you as the employer. So that in that circumstance, we probably would not be providing her the accommodation.
Yeah, I agree 100%. So just last thing, we have training that we can provide to you and your supervisors on documentation. Of course, it's different from this, but it answers 7 basic questions. Today we covered questions 3 through 5 for you, not completely as we would in the training. And in the training, we also do things like we use case studies, we use examples, you know, we take out names to protect the innocent. So if you need that kind of training, just let us know.
And I would just plug that, just documentation just a little bit more, not the training necessarily. In virtually every call that I have with a client when they're talking about an accommodation or perhaps a discipline or termination situation, I am always asking them, I know this is true of you as well, Jill, what type of documentation do you have? Documentation is not necessarily the most fun thing to talk about, but it is one of the most essential things to know as an employer. So
Totally agree. We're going to take a quick break, and as I say, we'll be back in 2 shakes of a lamb's tail with Mike Stabell.
Good afternoon, everyone. I'm Mike Stabell, and I'm going to be talking about the latest developments in the Department of Labor, U.S. Department of Labor's Wage and Hour Division. We're calling this Do You Recognize That Beat? Because I think as we go forward, you're going to find that you're going to recognize a lot of things from possibly 5 years ago during the Obama administration. So we'll just launch right in here as our time is tightly controlled. Let's talk a little bit about the big picture, and to a large degree, that's what I'm going to be talking about this afternoon. And that's because since the election and the new administration, there hasn't been a lot of changes in regulations and those type of things. It's more about the direction that the agency's taking. And I'd just like to start out by saying, when I first started with the Department of Labor, and those of you that know me know that I spent 33 years there with the Wage and Hour Division, Ronald Reagan was the president, so I hate to date myself, but of course I am. And once you become a career federal employee, you learn that with an administration coming in and a new one, there's always changes. And at least in the Department of Labor, more so. And it's not a secret that one party tends to favor, business-friendly regulations and rules. Other party tends to favor worker-friendly regulations and rules. And of course, that's exactly what's been happening here. And that's going to be a theme throughout my presentation here for the next 30 minutes or so. The changes, and I've got to go back and cover some of these past changes in order to put you in touch with what's happening right now. But I will just say, with those 33 years between the W. Bush administration to the Obama, and then the Obama administration to the Biden, I never in those years experienced the kind of swing in focus in labor laws, particularly wage and hour laws. So we're going to talk about that a little bit, and that's going to be kind of our theme. So we can get a real feel for where this agency's headed by looking at who was appointed to run these agencies. And of course, those of you that may be familiar with the Secretary of Labor, Marty Walsh, a very high-profile union official, former mayor of Boston, Irish Democrat, union stalwart, kind of a cliche, but in his case, it's the real deal. So we know exactly where he's coming from. Very focused on labor rights, worker rights, and things like that, not a secret. Now, interestingly, as we get back to this, the beat repeats itself. An administrator has been nominated by President Biden for the Wage and Hour Division. His name is Dr. David Weil. He is the same person that ran that agency under President Obama. And of course, I was still working there during that time, so I know Dr. Weil quite well. And this guy's made a career, basically, out of wage and hour stuff even before he came to work for the government, because he did a lot of contract work for Boston University. And he's the creator, I guess I would say, or originator of the term the fissured workplace. And I bring this up because it's going to be kind of the prime theme here for the next few minutes. The fissured workplace is mainly asking the question of who is the employer? And you may say, well, it's pretty obvious. If I go into McDonald's, McDonald's the employer. If I go into the Westin Hotel in downtown Chicago, they're the employer. Well, no, that's not the case nowadays. And Dr. Weil's claim to fame, if you will, is that he recognized the fact you can go into a hotel nowadays, a big chain hotel particularly, and the housekeepers may not even be employed, say, by Westin. They're employed by a contractor. If there's a restaurant, food service, the maintenance, all this. So there's not one employer involved in a workplace these days in modern America. There's multiple employers. And this is the issue that Dr. Weil has basically made his career on. So we know they're going to be looking at certain things that have to do with who is the employer. And we'll get into that some more as we move along. Also, for this year's budget, the year that started on October 1, the Department of Labor Wage and Hour Division received over $30 million more than they received last year in a budget. And their budget isn't that big, it's around $150 million. So that tells you that the administration is putting a high emphasis on enforcement of the law. And if you doubt that, nationally, the agency is hiring investigators all over the place. And I know the office I used to run, the Des Moines district, has added 4 new investigators, 2 in Des Moines, 2 in Omaha. So they're just on this ballpark along with everyone else. So we know pretty much where they're coming. Whoops, I'm jumping ahead. I gave you a secret name or secret slide in advance. When I was with Department of Labor, I was there for the entire Obama administration. And the type of people they appointed, as we're discussing here, many times in the lower levels of political appointees were very strong worker advocates. And we career people, I can tell you this now that I don't work there, we had kind of a term for those people. We called them the true believers. And true believers are fine, they're motivated folks, but unfortunately they tend to be rather narrow focused, and that was certainly the case with these folks. And I'll let you know. And you know, I'm a true believer too, but now I get to my slide. I'm a true believer in my harmonica. And yeah, it's a secret slide, and that's not my harmonica. Okay, I have 6, but I have one just like that. So just keep that in mind as you move forward. And someday when I present, I'll bring my harmonica and play you a tune or two, but not today, not today. So you get that idea of the personalities, the types of people that are put in place. These are people, again, in this administration, just like Obama, in these lower level deputy secretaries and so on, heads of agencies, all focused extremely on worker rights and worker protections. So what are we talking about specifically? Okay, I'm going to give you some of the points here. This comes from their own website, and I still keep in touch with a number of my former peers in Wage and Hour, and I've learned this from all of them as well. So standard operating procedure is coming back of assessing liquidated damages. Now, what are we talking about there? The Fair Labor Standards Act provides that an employer may be liable for back pay if they didn't pay their people in accordance with the law, possibly some fines or penalties, we'll get to that, but also starting again with Obama's administration, the agency started assessing an equal amount of back pay in the form of liquidated damages. Simply put, if you were investigated by Wage and Hour and you were found to owe, let's just say $5,000, okay? They're going to come and say you owe 10. And that's to the employees, not to the government, but it's just becoming standard procedure. Prior to the Obama administration, this was not standard procedure. Matter of fact, it was only done in a court of law, in a litigation proceeding. And I won't get into it for the time, but there's a lot of legal discussion about whether or not it's even in accordance with the statute, with the FLSA, that this is legal. But no one's challenged it successfully yet in the 8 years of Obama, and they haven't yet. So if you get visited, you just better assume that that's what's going to happen. The agency has also announced they're going to start a more vigorous use of subpoenas. They have administrative subpoenas and court-ordered subpoenas for the use of records, to get records and so on, and civil money penalties. The FLSA provides for fines. They call them civil money penalties for things like repeat or willful violations of the law, and for child labor violations and all those types of things. And it's been just said right out loud that they're going to be looking very strongly at utilizing those tools, as they call them. What has not been mentioned, but which I'm sure will be coming too, is the use of hot goods. And if you want to talk about a scary scenario, again, I will just touch on them. But hot goods provisions of the FLSA say if a product was manufactured or produced or created by employees who were paid in violation of the law, or by minors who were employed in violation of the child labor provisions, the Department of Labor can go to court and get a temporary restraining order to literally stop those goods from being shipped. And the scary part is, it's not just the employer who produced that product, it's anyone who gets that product up the supply chain. So we've had scenarios when I was working for the agency where, for example, I mean, this is years ago, it's allowable to say, but John Deere's subcontractor who made nuts and bolts missed about $200,000 worth of payroll, and these nuts and bolts that went for, a nickel a piece, a dime a piece, were put on, $1 million combines. And the Department of Labor, me actually, said to John Deere, your combines can't leave Waterloo until you pay that $200,000. And they did. Now, is that right or is that fair? I don't know, but it's legal. And I think you're going to be expecting this as well. So hot goods is a scary concept. The agency, Wage and Hour, has also made it very clear outreach and education is not their primary function anymore. It was under Trump. It's going to be investigations with all their new investigators and all their money. And again, they had a PAID, they call it, it's an acronym, but it's a self-audit where employers could self-report violations to the Department of Labor. Very, very rarely used, and I'm sure you can understand why. But they announced that that was ended within just a month or two of the election of Biden. They're promising to increase the number of investigations they make out amongst the employer community. And we get back to Dr. Weil again, utilizing the power of firms at the top of the supply chain. So think of John Deere again. What this Department of Labor wants to do is make the top of that chain, who has all kinds of subcontractors providing them their materials, to actually be the monitor of compliance for these subcontractors underneath them. And that's an actual stated goal for the agency, to put pressure on the top employers in the supply chain. The other thing that's been very clear by the little bit of regulatory work that the agency's done is they're going to focus on employment relationship, okay? Back to the idea of who is the employer, okay? So these are the type of things that are already coming out in the way this agency is moving. So you want to be aware of this, okay? So I want to get into some nuts and bolts for a minute and tell you what they've done. As these, how do I want to put it? Focuses have changed with the comings of new administration. I like to look at it as a pendulum that swings back and forth towards the workers, towards the employers. It's swinging so far, it's practically doing a complete circle these days. And when the Trump DOL took over, they wiped out a whole bunch of Obama's rules. And now it's kind of turnabout is fair play. So the Trump administration had put a independent contractor rule in effect that was actually a regulation, basically. I mean, it was guidance for sure. The current DOL has already said we're withdrawing that rule, okay? And that was effective in May. So we'll talk about this rule in a second, but I want to cover these regulatory changes real quick. Now, just recently, the agency announced they have not proposed a new rule. So to determine who's an independent contractor and who's not, you've really only got one source right now, which is this wage and hour fact sheet, which if you notice I've got it as a link, as well as the, everything in blue of course is a link. So we're going to cover a little piece of this fact sheet. But if you want to find out, and you're wondering whether one of your workers is a contractor or an independent contractor or employee under the FLSA, you're going to want to look at this wage and hour fact sheet 13, okay? Now keep in mind, I'm talking about contractors in light of DOL rules, not IRS, because don't be fooled, they're not the same rules. They're close, but they're not identical. So you got to follow which agency you're dealing with. The joint employment rule, this is another idea of who is the employer. And a joint employment concept in the FLSA is where two employers essentially share the work being done by a single worker, single employee. So the classic example of that is when you bring on a temp from a Kelly Services, a Manpower, or someplace like that, they come to your workplace, you're directing them, you're controlling them, your rules of conduct, deportment, attire are in place. You're the employer along with Manpower, and the key is, again, liable for any problems, okay? So that was withdrawn because, again, it doesn't make any, I'm not being political here, I'm just stating a fact. The Trump joint employer rule was more friendly to employers. The current crowd didn't like it, so they're going to put one out. And if it's anything like the one that the Trump people rescinded of Obama's, it's going to be quite restrictive. As a matter of fact, just a little plug for my blog, if you go on the Dickinson website, I have a blog called Wage and Hour Watch, and I did one on that Obama rule called You May Have Employees You Don't Even Know About. And that was because of this joint employer rule. So we're going to cover this a little more. But again, just like with independent contractors, the DOL did not put out any new guidance on this. They just said OCR fact sheet 13. So again, if you have contractors and there's some question of their status, I encourage you to check that out. You know, contact us at Dickinson too. We've worked with this a lot. So the question is, what is an employee versus an independent contractor? We know that this is a huge focus. It's been a huge focus with IRS for years. The state of Iowa's Department of Revenue has this as a focus, and so does the Department of Labor for all kinds of issues. Family medical leave, OSHA, wage and hour, all these people depend on this rule. So this is the test that is now in effect. So keep this slide if you don't keep anything else out of this presentation. And these were tests developed actually out of a Supreme Court case that was decided, many years ago. I want to say it was in the 80s. And it was just, everyone accepted it. And during these last, 11 years, 10 years, since Obama changed everything and Trump changed it back, it was interesting that the courts didn't recognize the Department of Labor's interpretations. They were going with this because their own Supreme Court had done it. So I'm just going to take 1 minute and hit some of these and make the comment. No one of these controls everything. No one of these controls everything. So I know you're going to say, Mike, this seems kind of vague. It seems kind of open to interpretation. Yes, exactly, it does. Like so much of labor law, federal labor law. But if you can see these 7 points, and I'm not going to say that if 4 point toward the employee and 3 point toward a contractor, well, then you go employee. You just have to judge the whole scenario, okay? So number 1, extent to which the services rendered are part of the principal's business, okay? If the company's utterly dependent on these workers who are being called contractors, well, that's maybe an indication they should be employees, okay? The permanency of the relationship. If I've worked for this company for 12 years, I've never worked for anyone else, you know, that's a permanent relationship, again, that points towards me being an employee, okay? The alleged contractor's investment in facilities, okay? I always used to tell people when I was with Wage and Hour, there's no such thing as contract labor. If all they're bringing is their 2 strong hands and their strong back to the job, no tools, no investment, they're probably employees. So they look at this as well with the Department of Labor. Control. And this was the one, number 4, that was at extreme odds between the administrations. And I have to say, the Obama people went way over the line on this. Because even though the Supreme Court said nature and degree of control, what the Obama DOL said was, you don't have to exercise any control. But if your arrangement, if your contract with the subcontract company gives you the potential to exert control, we're going to call that control. So it wasn't really a surprise when some of the courts didn't go with this. Contractors' opportunities for profit and loss, we know how that works. And employees do their money no matter what if they work, even if they're not that great. A contractor who screws up may have to come back and do the job for free, right? So that's an easy one. Initiative, judgment, foresight. Is this contractor out there looking for more work, aside from the company that you work for? And the degree of independent business organization. 6 and 7 kind of go together. So in the short time, you know, I could spend a half an hour in each one of these, but of course I'm not going to. But you may say to yourself, well, why is this a big deal to me? I'm going to tell you why. You may have something going on here you don't even really realize. And I want to give you one. I'm going to keep it to one story today, which is an all-time record for me. Well, I'm not done yet. There might be a couple more. But I've done this several times. I was talking about this situation where, and it always happens at banks for some reason, small branch banks that maybe hire their custodial janitorial service. They lose that service for whatever reason. One of their employees steps up and says, you know what? I'd like to do the janitorial for you. I'll do it as a contractor. So you just pay me as an employee from 8 to 4:30, and then I'll put on my janitorial hat and I'll clean the place after 4:30. And I've run across that numerous times in my career. I just had a presentation 2 weeks ago, and 2 people came up to me and said their bank that they worked at was doing the same thing. You can't really have a person be a contractor and employee at the same time, okay? So please, please, please remember that. Now, if this employee, there's rare cases, had their own business and they were cleaning 10 other locations and maybe their spouse helped them or their kids or whatever, that could be a different story. But the employee who only cleans the offices where they work all day long as an employee, no, it's not going to fly. So it really pays to do that. And I'm sorry I skipped ahead of you guys a little bit. I'm not going to cover this very much. This is another rule that the Department of Labor actually did issue since Biden took office. And this was for tipped employees. And the bottom line is this. A tipped employee can only receive that lower wage of a sub-minimum wage, which in Iowa is $4.35. The state has that. They have to be doing tipped work or work that's related to tips, okay, like rolling silverware, you know, bussing tables, things like that. And again, this has gone back and forth between Bush to Obama to Trump, and now we've got this. And just 2 days ago, they came out with their final rule. So this is the new rule. It goes on to say that you can only spend 20% of your time in this related work. And I think this was a wise move. I mean, it's not fair to pay somebody $4 an hour if they're not doing tipped work and they can't get tips, okay? Minimum wage, people ask about minimum wage. Some of you may or may not be aware of this. Even though there's nothing congressional that I'm aware of in committees or anything discussing a raise in minimum wage, everybody's talking $15 an hour. And back in April, President Biden put an executive order that's in place right now that anyone who holds a contract to do work for the federal government, typically services such as janitorial, guards and stuff, or construction like highway work, working on our new federal building, things like that, they have to pay all the workers who help support that at least $15 an hour. And there's been fuss about it. There was talk of lawsuits, but nothing's happened yet. And so right now, this is in place. So I think we're at a point where the 2022 election is going to determine what happens with minimum wage. I will tell you an interesting fact that of the last 5 minimum wage increases, 4 of them came about in an election year. I can't imagine why, can you? I just can't imagine why. But we do know why. So we can expect this to happen again, depends on what happens in Congress next fall, okay? You remember the big brouhaha not too long ago about the white-collar overtime exemptions, right? Our executives, administrative, professional, EAP people. Again, there's been no legislative movement there, but if you remember, there was a huge brouhaha, and the government proposed raising the salary test to 47, and after a whole bunch of judges restraining the implementation of the law and everything, they finally came to this 36,000 and change that they have now. Well, Walsh mentioned in his confirmation hearings that he wanted to go back up to the original 47,000. And of course, some of the Democratic congressional people are on that. There has been no regulatory action taken to this point. Again, I think we're going to see what happens in the election, and we could see that go back up. We shall see. Time will tell. The other thing that I really kind of this has a place in my heart, these opinion letters. And those of you that have worked with me before know I am always promoting this. But Wage and Hour is one of the very few agencies in the federal government that you can write a question. Nowadays, you can email a question to their head guy, to Dr. Weil himself, and saying, I've researched the regs. I don't see an answer to this question. Can you answer this question for me? And they will answer it. And then they post it on their website for all the world to see. Now, don't worry if you're thinking about this, because they don't put the name of the company or the requester of the question in the letter. But this was a great source of guidance for employers, particularly, to find out, what do I do here? And during the height of opinion letters prior to Obama, they were putting out 50 to 60 a year, and that was just FLSA and FMLA. Now, when Obama came in, because they were so fixated on enforcement, they eliminated them entirely. And they created a whole new thing called the Administrator's Interpretation, and they put out, I think, 4 in 4 years, because this came out in the second half of their administration. So now they're back, and Trump brought them back, which is a wonderful thing. And they're putting them all out, and they're out there. So if you have a weird question, or if you can't sleep some evening and you need something to put you to sleep, just go to that website there and look up opinion letters, and you can read some and be asleep in just a few minutes. So on that note, I'm going to wrap it up and wish everyone a good rest of the seminar. And when we're all done, get out there and enjoy this beautiful weather. Thanks, everyone.
We're going to take just a couple of seconds to switch so that we will hear from Rachel Soderstrom in just a couple of seconds. everybody. And I have the pleasure to introduce Rachel Soderstrom, who will speak next on lessons we learned on remote work from COVID-19 and what will stick with us. You all were introduced to Rachel last year. She talked about COVID-19 litigation. She's kind of handed that baton off to Sierra McConnell this year, which Sierra and I will discuss at the very last session, which comes next. But right now, I want to turn it over to Rachel to sing us an old song in a new arrangement.
Hello, everyone. As Jill mentioned, my name is Rachel Soderstrom. And last year, I did speak on COVID-19 litigation and what was going on at that time. And at the end of our session last year, we made predictions on what we thought would happen next year as COVID-19 continued to progress and as workers and employers continued to revise policies and as laws became revised as well. The prediction I made was that that as we began to get back to a post-COVID world, that remote work was going to stick around. I suggested that employers should turn to their employees and look at what they're considering and what their preferences are as a factor in considering whether to continue remote work past the pandemic. As some news stories have shown, employees are demanding work from home as an option. In fact, in a recent survey, 70% of employees say that being able to work from home for at least part of the week is a top criteria in their selection of their next job. 73% of employees who have worked remotely during the pandemic would also like to continue doing so. However, it's not just employees that we are seeing wanting remote work. There are also several benefits to the employer that come with remote work. And in a survey of over 100 executives, 9 out of 10 executives stated that they plan to continue remote work in at least some fashion after the pandemic. The McKinsey Global Institute on the future for work after the pandemic suggests that remote work is likely to continue, though at a less intensity than at the pandemic's peak. The report analyzed more than 2,000 tasks over 800 different occupations across 8 different countries. And the conclusion that this report came to is considering only remote work that can be done without a loss of productivity, we find that about 20 to 25% of workforces in advanced economies can work from home between 3 to 5 days a week. Additional numbers for that, just so you guys are aware, the report also concluded that 17% of jobs could be worked remotely 1 to 3 days a week, and then 61% of jobs can be done remotely 1 day a week. But these numbers represent 4 to 5 times more remote work than before the pandemic and are prompting huge changes across industries. So, with statistics like this, it seems fairly clear that remote work is going to continue in some fashion in a majority of companies and industries as we move forward. We've already seen some of those remote work policies be implemented. And I'm going to go over some of the key things that employers need to consider and know when it comes to implementing those policies and acting on those policies. The first thing employers should do is consider tasks that employees can do at home. The McKinsey Global Institute report noted that negotiations, critical business decisions, brainstorming sessions, providing sensitive feedback, and onboarding new employees are all tasks that should be done in the office. They're more effective in the office, they're communicated more clearly in the office. These types of tasks should be done in office. But employers should look at tasks within within employees' job functions to determine which of those could be done at home and implement that into their policies. On the other hand, some tasks that were not that are not best done in person, that employers have reported that they are for sure going to continue post-pandemic are Zoom meetings. I know everyone is about fed up with those at this point, but it really is an efficient way that employers have seen to get meetings done and for everyone to get together and stay connected while working remotely. And then those individualized tasks that are key to individual employees are also tasks that could be done at home. Oh, there is my secret word, the clarinet. I used to play that in middle school, so fun. The next question that employers will need to consider is who should be allowed to work from home. So in addition to what tasks can be done at home, employers need to decide what criteria they are going to use in determining who can work at home. For example, must the employee have performed work for the company for a certain amount of time? Must the employee demonstrate proficient work before being allowed to work from home? Are the employee's tasks one that can be managed at home? And what if the employee has a demonstrated background of workplace problems or workplace non-productivity? What can employers do there? Those are all questions that need to be considered when determining who can work from home. And in considering these questions and drafting policies, employers always need to ensure that the criteria that they rest on are objective and that they are related to a legitimate business purpose. The criteria cannot simply be random criteria, but they need to be objective and legitimate business purposes, because when employers are implementing the policy, they need to ensure that the criteria are applied consistently across employees in order to avoid some sort of illegal discrimination or retaliation claim down the line. These objective type of criteria help employers to apply criteria consistently across employees. And my last bullet point on this page: what if an employee requests as an accommodation to work from home? And what if the employee does not meet the remote work criteria, or the employer doesn't have a remote work policy? In that case, employers should be prepared to engage in the interactive process of requesting an accommodation under the Americans with Disabilities Act. Though in the past, working from home has not always been seen as a reasonable accommodation, with the pandemic and the extent that companies went through to keep their companies running over the pandemic, the work from home idea of being an undue hardship is not as strong. Of course, there are still arguments for that, but employers should be aware that because working from home has been shown to be productive and efficient, that though they will need to consider those types of requests in the future. Another big issue that is seen when employers decide to do remote work policies are if their employees live in a different state. As I sort of mentioned at the beginning, employees are looking for jobs outside of their home state. Websites like Glassdoor and like headhunting firms often are posting remote work jobs on their websites. They've seen a huge uptick in those types of jobs. So if an employee can't get their remote from work schedule in their home, they can always go to those sites and do that. So we do have a lot of employees working in different states that the company is registered in. So in having those employees employers just need to be mindful that not all states have the same regulations. For example, some states require a higher minimum wage than others. Some states require employers to reimburse employees for their at-home office expenses. So just being aware of the specific state's law as it relates to just doing business in general. And then under the Fair Labor and Standards Act, if the state does not have a state-specific law, when it comes to business-related expenses, employers are prohibited from requiring any direct payments or reimbursements for such expenses if doing so would cause the employee's wage rate to fall below the required minimum wage or overtime pay threshold. So those are things to keep in mind. Additional protections under other state laws that may not be similar to your home state are that a lot of states have more expansive civil rights protections. So making sure that any activities are protecting those employees in those states. There's also different tax considerations that employers need to consider. Does the employer need to pay unemployment taxes in the state where the employee is located, or in the state where the employer's home office is located? Those are questions that can vary state to state, and those are things that need to be considered. Another issue in addition to unemployment insurance is workers' compensation. Many different states have different requirements for workers' compensation coverage, and they vary on whether out-of-state employees are counted in the minimum requirement for compliance with their workers' compensation laws. And on the note of workers' compensation, another possible issue that employers are going to run into that they need to consider are workers being injured at home while doing work. It's more difficult to determine whether an employee was doing work while they were injured when they can't be monitored at work, but there are some steps that employers can take or consider to implement in order to minimize potential claims regarding remote work injuries. Some of those examples are requiring a written authorization before the employee can work remotely, updating and maintaining accurate employee job descriptions and expectations, having employees define their home office space so they have a limited area where they can claim they were injured, providing employees with information and training about setting up safe workstations, providing a safety checklist, and then having employees report injuries immediately. It sounds obvious, but having that requirement that employees report the injuries immediately helps to ensure that the events are well documented, and so that you have a better idea of what you're working with down the line. Another issue that employers have ran into are wage and hour issues with work from home. More specifically, as it relates to exempt and non-exempt workers. Failing to properly classify your employees can result in substantial costs to the employer. So for exempt workers, just a couple reminders. Keep in mind that their classifications depend on whether they meet the minimum salary threshold of $684 per week and the primary test for the specific exemption under the duty of which they are, or under which they are classified. Moreover, exempt workers are generally entitled to a full week's salary for any work they perform remotely. Before deducting an exempt remote worker's weekly salary, employers should remember that they can only do so in limited circumstances. Turning to the other side with non-exempt workers, non-exempt remote workers are entitled for the hours they actually work, including any time that is not scheduled or that is not authorized, or that is unauthorized overtime work. So employers definitely need to ensure the accurate recording of all non-exempt remote workers. Make sure that that is well maintained. Employers should also clearly communicate in writing that off-the-clock work, underreporting of hours, and unauthorized overtime are strictly prohibited. A final major areas employers will want to focus on in preparing these remote work policies and these the company company data and employee privacy. These are major issues that employers have been running into with remote work. Employers, of course, want to make sure that their employees are doing work while they're not in the office. So monitoring has become popular among employers. And when remote work is happening, that allows for employees to access company data on both personal and work devices. So it's necessary for companies to communicate expectations and procedures to employees. As it relates to company data, a robust IT department is ideal in these situations. There are also best practices to follow to ensure that company data stays safe. Some of those action items include reporting anything suspicious to the IT department, regularly changing passwords and making them more complex, avoiding public Wi-Fi, trusting only well-known sources of information, and not sending corporate data to personal email or cloud accounts, and not allowing family members to access company systems or devices. Communicating those policies to employees is important because it's going to take an employee and an employer effort to keep company data safe. The employer can do everything that they can, but the employee also has to do the things that the employer is requiring. So clear communication on protecting company data is very important. When it comes to monitoring employees while they're at home, there's a lot of different laws that can be affected when that can be violated, when monitoring employees is done at home. For example, it seems a little off, but some states have social media policies that prohibit employers from accessing employees or from requesting employees' social media passwords and login information. And while monitoring may not be considered a request, looking at the features of the software like key logging, employers are able to gather that private information and confidential information. Additionally, there are privacy laws, both federal and at the state level. Those can be implicated when monitoring and recording telephone conversations, Zoom calls, team meetings, emails, and internet usage outside of a legitimate business purpose. This is not to mention the traditional torts of invasion of privacy, as employees have a reasonable expectation of privacy in certain circumstances. Accordingly, an employer's best practices in monitoring remote workers include Of course, disclosing the monitoring to employees, managing expectations. Employers should be clear to employees what they expect, and employers should manage their expectations. It's not possible that employees are going to work every second of every day. So employers need to be considerate of that, that fact and manage their expectations as when it comes to remote work. In conducting the monitoring, employers must do so equally and consistently. If an employer is only monitoring certain employees, that makes a good case for potential retaliatory motivated actions down the road based on information discovered through that monitoring. So as always, just be consistent in your application of your policies, avoiding those types of retaliation and discriminatory claims are very important. And then the last tip for monitoring is to always be prepared to investigate. If you are going to have the policy, you need to make sure you're going to investigate any irregular activity or harassment that may be found in the monitoring. Just making sure that you're taking care of those things and following through with the policies. I think I'm done a little early, but I don't have anything further, so.
That's okay. Thank you so much, Rachel, for that informative information. We will take a quick break and be back at 3:15 with our last session, which I hope you all are waiting for, on federal vaccine mandates. See you soon. Hello, everybody, and welcome back to the last session of the Dickinson Law Employment Law webinar. And I am changing the title of this one. It's no longer going to be called Second Verse Federal Vaccination Laws. It's going to be called Ad Lib Federal Vaccination Laws. And that's because we just got 2 new federal regulations this morning, and Sierra has been back at the office since she left you this morning trying to digest the OSHA regulation. So we are going to be riffing here and ad-libbing on where things went, how that maybe dovetails with Iowa's new law that was passed last Friday. So we're going to dive into this. And we did come up with, 2 weeks ago when our materials were due, we did come up with some questions that we had. And basically, I'm going to pose those questions to Sierra and see how OSHA has answered them. Now, this said, we are drinking from a fire hose right now. So there were pages and pages to be digested. We cannot guarantee that anything we're going to say is 100% correct. May change later, but this is what we can get out of it in a very short, about, 6-hour period here, right? Okay, so moving forward, there already were several federal vaccination laws in place before today. So the Centers for Medicare and Medicaid Services had some for long-term care facilities that first came out in May 11 of this year. Then OSHA had its first ETS on the pandemic for healthcare workers only that came out in June. So what we're dealing with now is what we called the second verse. And this is the federal contractor rules that came out a couple of weeks ago that we've been digesting and working with our clients on. And then just today, just this morning at like 7:45 a.m. our time, the Centers for Medicare and Medicaid Services came out with their interim final rule, which we are not going to talk about today. And the OSHA second ETS came out for employers with 100 or more employees. And that's what Sierra is going to try to help us with. So we're diving into the questions. Are you ready to ad lib, girl?
Here we go.
All right. So which employees count towards the 100+ threshold?
It's 100 employers across the nation. So if you have multiple sites, you have to count every single employer. Some examples. Employees.
Okay.
So an example, if you own a construction company and you have multiple job sites, even though you might only have 20 employees at one job site, you might have, 10 job sites. So every single employee that you hire is counted towards that. Now, what about remote workers? Do they count? Yes, absolutely. They're counted in whether or not the employer is subject to the ETS. Now, it gets complicated when we discuss what employees are subject to the ETS, because that's different. There are exceptions for some of the employees for accommodations, or let's say if they are remote workers, which we'll cover in a little bit.
Okay, so let me ask some follow-up questions. So if I'm a big company, holding company, parent company, and I've got all these subsidiaries, different federal ID numbers, different names for the companies, different workforces, do I have to sweep them all up and they're all part of my one company for the 100+?
It depends. Good lawyer answer, right? It depends on, one of the examples was whether or not you have one department doing all your safety regulations for all your different entities. If you only have one department per se that's overlooking all of them, then yes, you're going to be covered.
So it sounds like kind of an integrated enterprise rule. Did they use that terminology at all? No? Okay.
Check back with me later.
To come
to see on that one.
I should also say that once we have digested this information, we will push out more information.
Absolutely.
That will either be in the form of blog posts, a series of them, another separate webinar just on these topics. So today is just sort of a little teaser to get us started. I think you have to give everybody, whoever your counsel is, a couple of days at least to digest this stuff and push out some information and answer your questions. All right, so as far as counting employees towards the 100, do I have to count noses, like part-timers count, seasonals count, or do I get to count just full-time equivalents?
Part-time employees do count, but independent contractors will not count. So
Of course.
you
All right.
are counting your noses. Remote workers, part-time employees are all considered 100.
Great, you're doing wonderful. All right, vaccination. Does it say what it means to be fully vaccinated?
To be fully vaccinated, it's 2 weeks after either the second dose of the authorized 2 doses or after 2 weeks after the 1 dose.
So the usual thing.
The usual.
Were boosters addressed at all?
Boosters were not addressed, but interestingly, it did say an antibody test can be used because they say it's a COVID positive test or a COVID-19 diagnosis. So
It can be used for what purpose? To say you're vaccinated?
No.
Oh, okay.
No, you're right. Not vaccinated, but those 2 different testing comes in later.
Okay, so we're going to get to that when we get to the
Yes,
testing.
yes.
So I can't say, well, it counts as being fully vaccinated if I've had an antibody test and I have antibodies at a certain level in my blood. That's not going to cut it.
No, but it's whether or not
Okay.
you're clear to come into work. Yes.
Got it. Okay. By what date do employees have to be fully vaccinated, or is that even a date?
I'm not 100% sure on the fully vaccinated. January 4th is when you need to be in compliance. Whether that means you're in compliance that you're making sure your employees are getting their vaccination or at least in the process of that by January 4th, or whether or not they must be fully vaccinated, I'm not 100% sure on that one. But the 60-day mark from when it's published, which this is officially published tomorrow, that's when you have to be in compliance with the ETS.
Okay. And we talked about the antibodies already. What if I had COVID-19 and I got those monoclonal antibodies, and it's contraindicated for me to get the vaccine until so many days after I've had that injection of that treatment? Does the ETS address that you can kind of defer the vaccine if you're in that situation?
The ETS does not specifically do that, but they said they're going to be releasing those frequently asked questions like they did for the federal contractors. And with the federal contractors, they did say that would be a reason to delay your vaccination. So if we were predicting, we're going to say likely that's going to be an allowance to delay, but maybe not completely cut you off from being able to.
All right, got it. What are the record-keeping requirements? What do we have to do? What can or can't we do?
You have to keep the records, right? So you have to you have to show their proof that they actually are vaccinated. And this can be in several forms. It can be through, that card that everyone gets, or a note from an authorized doctor. And you can even get a written statement from your employee saying, I cannot find my card, I am vaccinated, and it comes with a clause saying, I'm not lying, this should be fraudulent, and they have to prove that they tried to get the card. So
Does OSHA provide this form or this statement, or they just tell you what has to go in?
They provide a little example clause that we can use. Yes.
Okay, all right. So do we have to take copies to prove the vaccination status of the employees, or is it like an I-9, we can choose not to take copies and we can just look at them and say, yeah, looks good to me?
I'm not 100% about the copying of it, but you do have to keep good enough record that you can go back and show that each employee is.
Okay, interesting. So maybe still something to look at. What about new hires? Do they have to be vaccinated upon hire, I assume, January 4th or after?
It didn't say whether they have to be right away, but it did say new hires should be reasonably compliant with your policy.
So maybe they could give them some time. Maybe there's some flexibility built in.
Right.
Interesting. Maybe. Okay. Employees working remotely, do they have to get vaccinated or be tested?
They are actually exempt under the ETS, so they do not have to become vaccinated or comply with your policy as long as they are completely remote. If they come in at all, they are subject to your policy. So this policy that you're mandated to implement, write and implement, is either a vaccination mandate, or you can implement a face covering requirement and testing once a week or within 7 days.
Wow, that's a lot to unpack. So first let me back up. What is this mandatory policy thing?
So that's what the ETS is. So it's mandating every employer with 100 plus employees to write and implement a policy that either mandates vaccines, or they can do a second option, which they really make it preferred that you mandate these vaccines, and you can implement a policy that allows the employees to not become vaccinated, but they have to be tested once a week or within 7 days, and they have to wear face coverings when they're in their workplaces.
Yeah, and I saw indoors as well as in vehicles.
Yes.
Is that right?
Yep.
Okay. So you got to have a policy. Are they providing a sample policy?
Not yet, but they promised they would give you tools in the future.
And is the deadline to have the policy January 4th or 60 days after the what?
No, the deadline for the policy is actually 30 days, so this is December 5th.
Ooh, so that's a little quicker.
Yes, yeah, 30 days to make your policy.
Okay, so what you're saying is what we had kind of anticipated, which is the employer can choose to do testing in lieu of vaccination, or they can choose just to require vaccination.
Right.
And then testing would only be allowed for what? Those people that get reasonable accommodations?
If the employer doesn't, it's up to the employer whether they're mandating the vaccine. So if they don't and they're allowing you to get tested, then you don't have to, it doesn't say that it has to be an accommodation. Someone could just prefer or refuse to get vaccinated, but then they're subject to testing and wearing their face coverings. Interestingly, though, the employer has to pay for the vaccination, but they do not have to pay for your weekly testings, and they do not have to provide you with the face coverings.
So, of course, vaccinations are still free under government programs, so the cost of the test, or the cost of the vaccination itself, that doesn't have anything attached, but we'll get to that in a little bit. Yeah. So, how about, does the ETS address anybody else in the workplace that isn't an employee? Like, you talked about independent contractors aren't covered, but what about rules for visitors, volunteers, patients, customers? Does it say anything about that?
Not that I read, no. It's just your employees.
Okay, got it. So it doesn't say anything about reasonable accommodations per se?
No.
Okay, so all of our questions about reasonable accommodations are not really going to be addressed, all right? So we're going to bypass those. And we're going to assume that existing reasonable accommodation law will apply. All right, let's move on to the testing. Okay. You've been like a racehorse out of the gate. You want to get to this testing, so let's cover it. So you've already said that employers don't have to mandate the vaccine, but it sounds like every employer is going to have testing. So it's anyone who isn't vaccinated, or you could just say, hey, I'm not going to require the vaccine for anybody, and I'm going to do testing instead. Is that right?
Right.
Okay. So while the vaccine mandate is preferred heavily under the regulations, it is something that you actually, as an employer, could give up and just go to the testing.
Right.
Okay. And then you'd only have to test the people who weren't vaccinated.
Right.
Okay, got it. Is there any information about what test is going to be acceptable for testing? The easy PCRs that have false negatives and more false results, or the higher level, more expensive, I don't know, what is it, the antibody test, I think. Not a doctor.
What I read was any of the authorized ones, including those emergency use ones, and you can do this at home, the self-take ones, but if you do the at-home ones, you can't self-read your results. That was very clear. You have to have a medical person read it, or have a telehealth person there instructing you how to read it. Otherwise, they said it wasn't reliable. Okay, interesting. Because one of the things we know from the CMS and the earlier OSHA ETS was that the testing needed to be done by a trained medical professional, or you could get a CLIO waiver and have some other people do it on site. So now it sounds like you can't have employees do it from home, except that they can only take the test sample and maybe put it in the kit. They can't actually read the result and tell the employer that, result was negative, don't worry about it. It has to be somebody else. Exactly.
Oh.
Exactly, and the employer has to be very clear on how they're going to require the taking of the test, what the employers decide what test they're going to take, and how the employee is going to be required to report that to them. That all has to be very clear within your policy that you're giving, so that your employees know exactly what they're subject to and what the requirements they are supposed to follow from here on out.
Oh my goodness, I'm seeing problems all over the place. It's like flashing lights coming at me. Okay, what if testing is unavailable or the results can't come back timely enough? Is there anything in the regulation about that?
Not that I read, no.
You know, there's a lot of concern about testing kits not being available in sufficient quantities. I've already had employers who've contacted like public health departments or their local hospitals to say, hey, can you do testing for me on site or there at your facilities? And they're saying, nope, don't have the capacity for that. You're going to be on your own. So I'm concerned about how the rollout of this is going to go. I think you mentioned it a little bit, but who pays for testing?
So like you said, I guess I said.
Yeah, you've been saying it all, girl.
Yes, so the employer is not required to pay the employee to get tested, and they're not.
Okay, so difference between leave and the cost of the testing. So let's stick with just cost of testing right now.
Okay, yeah, so the employee is responsible for the cost of testing.
Woo!
And
That is not
face
what I
covering.
anticipated.
Yes.
So they are responsible for finding the test that is approved by the employer and paying for the cost of it.
That's what it sounds like, yes. And I think the point of it is really to encourage employers to do the vaccination.
Right. So is that true also for people who are being reasonably accommodated, or it doesn't say?
It doesn't say.
Oh, because, you know, we kind of thought maybe people being reasonably accommodated were with the employer's approval, and therefore the employer might have to pay for those. And then people not being reasonably accommodated that didn't have, you know, a legal conflict or exception to be made, that maybe they would only be the only ones to pay. But now it sounds like...
Well, some employers may have to if there's other laws that will require them. So if that
okay.
law does require
Sure.
them, then they will. Or if a union agreement requires them to, they'll still be subject to all of those.
Correct, and I saw some of that in the one-page summary that I read, which made me an expert. And I think part of what they're talking about there is like the Fair Labor Standards Act or minimum wage laws. If the employee paying for the cost of testing each week would take their wage below minimum wage because, you know, they deduct that from their wages and now they're below minimum, that wouldn't be allowed. That you'd have to make up and get them back up to minimum wage. So I think that's one of the potential laws that we're talking about here. Also maybe collective bargaining agreements that might not, you know, allow the employer to shift that cost to the employee.
Exactly, yes.
Did it say anything about negotiating with unions about your policy?
Not that I read, no.
I'm thinking you're gonna have to, but I don't know, maybe not. Okay, so you talked a little bit about who can administer tests, that they can be self-administered, but the results have to be read by some kind of healthcare professional.
Yes, yes.
Wow, okay. How will testing apply to on-call employees or employees who don't work very often? You know, they're like, hey, we need somebody on Saturday, can you work it? How are they going to have to keep up each week with testing, or can they just be tested within 7 days before they come into the workplace?
It sounds like within 7 days. So it would be like the same thing with a remote worker. If you're going to require them to come in for a meeting, they're still going to have to be tested within 7 days of coming in.
Okay,
So-
got it. So now let's get to that leave time or compensable time for going out and getting tested. What do they say there?
So an employer is required to pay up to 4 hours of time to get a vaccination. That was your question, right? For the
Yes.
vaccination. Yeah, we're on the vaccination now. So up to 4 hours is to receive the vaccination, and then they have to pay reasonable time to recover.
Okay. And does it say that that's some extra special new bank of paid time, or can we use existing paid leave banks?
The way I understood it, so the 4 hours
Disclaimer, that means there's a disclaimer.
Yes.
As if we haven't put enough of them on here already.
So the receiving the vaccination, the 4 hours that are required to be paid, that's on top of. You can't use a bank that you've already had.
Oh, that is not what they forecasted would happen.
But the reasonable time to recover can be
from a bank.
from your sick leave. Yes.
Okay, interesting, very interesting. Okay, what about testing time? What if I have to go somewhere to get tested because no one's coming into my workplace to test me and I can't test at home. So I have to go to like the local pharmacy or the local hospital or something to get tested.
What I can remember right now is there's nothing, the testing seems very employee required. Like the employee,
It's on them.
it's on them to do it. And I think that's really, again, just so the employee decides to get vaccinated.
Okay. And it sounds like there is a masking requirement along with the testing. So it's not
Yes.
just testing, it's masking.
Yes.
Is it social distancing too?
It is not. They only incorporated the testing and the masking because they thought there would be too many requirements and they didn't know how this would affect each business individually because it's such industry-wide that they only could make it legal with the testing and the mask requirements.
Okay. Is there any social distancing in there? I'm thinking not because it's too many industries.
There's too many
can't.
industries, they don't know which ones
Okay.
could do it.
I think we've covered the leave questions. So miscellaneous. Does it say anything about vaccine incentives, whether they're still okay?
Not that I can remember,
No?
no.
Okay. I would think maybe not. Does it say anything about the penalties? How will penalties be assessed? Is it per employee,
Right.
per day, per employee, or just, hey, your employer doesn't have the policy in place, that's one single violation, and that's the up to, whatever it is, which in Iowa is at least $9,000 some dollars as a minimum and can go as high as, I think, $136,000 something.
Right, so they made it very clear that they can penalize an employer per violation. It's not just a one-time, you're not in compliance. So each time that they show that they violated it, they're going to be.
And what's a
They're gonna get fined.
violation then? Is it each employee who's not in compliance? Each week where we didn't get the test result negative?
I think it's every time the employer doesn't follow their policy. So if they don't test that person and it's shown, then they're not following this ETS. And they also have the ability to do this extra penalty for if an employer is blatantly not following the ETS. So it's willful and egregious and all those things. And I saw somewhere, it might have been just a blog post or something, that this could be up to over $130,000 that
Right.
this penalty is going to be.
Right.
So, I mean, they're really
Per
going down
violation.
it. Per violation. They're not just saying one time and done under the general duty
So if an
codes.
employer thumbs their nose at this and says, I'm just not going to do it.
Yeah.
I'm not going to have a policy. I'm not doing testing. I'm not taking the record keeping. They're going to get dinged for a willful violation for each and an egregious violation for each one of those.
Exactly, yeah.
Okay.
Yeah.
All right. So it could be super duper costly to not comply. So is anyone challenging this rule, do you think?
There's a lot of states promising they will, including Iowa. Governor Reynolds has already said a suit's coming. She's going to file a suit on this. And of course, we've seen with the federal contractors, people are suing over that as well. So yes, absolutely, we fully expect legal
Including
challenges.
Iowa,
Including
suing.
Iowa,
Yes.
we'll be on that list
Yeah.
too. So
And I don't suppose you've seen it or have any predictions on whether those challenges could potentially, work or not, or whether,
Right.
because I think some employers out there are thinking, I'm just going to wait for these lawsuits and they're going to stop it, and so I'm not going to have to do anything.
right.
What do you think of that?
I mean, to that point, OSHA, even if this, so the ETS is only in for 6 months, right?
Right.
And so even if we are challenging these legal challenges, in 6 months, there's nothing to be challenging anymore because it'll be a final rule, right?
Right, that's the other thing. They said that even though this is an emergency temporary standard for 6 months, it's actually the notice that they're going to do a final rule for
final
this.
rule, right.
Plus, they also might change the rule. In fact, they might go below 100 employees.
Right.
Yeah,
Yeah.
that's the other thing that I saw that they signaled, that they're doing further research on it, and the rule might apply to smaller employers.
Yeah, and it sounds likely. Like when they have time to research and develop the legal standing to apply it, they're going to do it. They also said that they originally looked into, we'll get to the legal challenges apparently, but they looked into having 150 employees, but then it was like 67% of all the industries would be covered with 150 or more employees, but they decided that 100 would do it because an even more percentage would be covered. So they're really trying to cover as much as they can, and they're going to keep doing that until everyone's covered, I think.
Until we get it done.
Yeah, so there will be a lot of legal challenges coming.
Gosh darn it. So the next thing to talk about, just very briefly, because we have limited time left, is, oh wait, I have to give you the secret word for this session, and it's the future. We'll talk about that in a second, is the Iowa law that was passed last Thursday and signed into law last Friday morning by Governor Reynolds. And what I want to say about that is, at this point, I want to just refer you all to a blog post that I wrote about this on the iowaemployerlawblog.com, and it was called, "What Does the New Iowa Vaccine Waiver Law Do?" So, and that, I walk through what the waiver law does and what I don't think it does, what impact I think it may or may not have on reasonable accommodations, the unemployment provisions in it, and some unanswered questions. Now, again, that was me drinking from a fire hose,
Right,
because
yeah.
I looked at the legislation on Thursday when it came out, wasn't sure it would pass. When it did, Friday morning, I'm up at the crack of dawn, and I'm trying to, digest it. It's not a very long law, but thinking it through and what all the impacts are were kind of the key there. So, I commend to you my blog post about that. But where I want to link this into this is, I read in the summary, and you tell me if I'm right, that the OSHA standard specifically says it preempts state laws that would be contrary to it. Is that right?
That's absolutely right. Yep. And there's a couple pages on it making sure it's explicitly clear that any state or local law is preempted by this that would in any way contradict the workplace mandates that they're having through this ETS. So
Yeah,
yes,
yeah.
so
They
that
are
would be preempted.
really trying to set this thing up for success
Yes.
in what the policy of the administration is.
Right.
All right. Well, thank you so much, Sierra. This has been wonderful. And so go back to my secret word for you all. This is last Jill in 1979. That is me graduating at the very end there. It's all of the seniors in Manila High School's chorus singing a song that I wrote for us called The Future. And that's your last secret word, the future. And, I thought I knew what my future held in 1979 when I graduated from high school, but I truly had no idea. And it's sort of like, I thought I knew what was coming out in this ETS today. There'd been a lot of leaks, but I really didn't have any idea, and some of the leaks weren't entirely accurate.
Right.
So I think that's going to be the case moving forward. This vaccine mandate stuff is not going away, and I don't know when the COVID music is going to stop. It just keeps playing and playing and playing, and I'm waiting, but we just all have to kind of keep singing and dancing to the tune as best we can. And we're trying to help you all as much as we can. Look for in the future some additional kinds of webinars and tools that we can provide to you to try to help you. But one thing is clear to me. It seems to me that an employer's policy is going to have to be flexible. There's options that they get to make. So coming out with one particular policy, or even here's your 5 or 6 different options, is going to be really difficult to do.
Right.
I'm not saying it can't be done. There's going to be people doing it, but I think it's going to be hard to do. So moving away from vaccines to our closing, I want to thank you all so much for attending this year's virtual employment law seminar for the Dickinson, McAmin, Tyler, and Hagen law firm. We hope you found all of this information important. We hope you found it helpful, and we hope it helps you get back into the groove and maybe find some new energy to move forward. Please look for in your inboxes, in your emails, or maybe your spam filters later this afternoon, an email that will have a survey. And just take a few minutes to fill that out for us. Let us know how we did. We really, really, truly do value your feedback and use it. And of course, look for more on next year's seminar, as well as potential webinar and other tools coming at you. And we look forward to seeing you actually in the flesh next year. We certainly hope so, because we so miss you. Thanks. Bye-bye.